Associate Development and Court Department, hear ye. All persons having business before the court will draw here to their attendance and shall be heard.
Thank you. Please be seated. First case on the calendar for argument is number 814, People versus Curry. 814.
Morning. May it please the court, Cleo Weiss for Eugene Curry. My client served over 5 years of probation before he was resentenced to prison. He's now served 2 years in prison and an additional 1.5 years of post-release supervision. But because he served his full 5 years of probation, the time was never told. His resentencing in December of 2021 was illegal.
Okay, so let's talk about those 5 years. When do you think they ran between? Certainly, we would start in 2016, okay?
Right, he is sentenced on July 5th, 2016 to the 5 years of probation.
Okay, but things happened in between, right?
Yes.
Okay, and you're saying those things aren't significant enough to stop the clock from the 5-year probation for murder?
That's correct, because under CPL Article 410, the only procedural device that tolls the time is a declaration of delinquency, and it must be filed by a court according to CPL 410-30. And that's really the exclusive means to toll the time. And to do that, all that Supreme Court needed to do is find a reasonable cause that there had been a violation of probation and file that declaration of delinquency. And that is supposed to happen within 72 hours of the probation office requesting such a declaration of delinquency, which happened in this case on January 4th, 2018. But even that it doesn't happen within 72 hours, as the statute tells us, in this case, it simply never happened. And I think not only was there never a written declaration of delinquency filed, but Supreme Court's course of action shows that it was choosing not to. And the court has the authority to choose not to because it was trying to work with Mr. Curry for those first 11 months.
As you know, Mr. Ash argues in his brief that probation was told when your client admitted the violation of probation. You disagree with that, I assume? I
do disagree with that. So the people are arguing that essentially the admission which takes place on December 13th, 2018 counts effectively as a tolling. And I think that's wrong for 2 reasons. One, again, I would return to the fact that the statute makes perfectly clear that the declaration of delinquency is the sole exclusive means procedurally to toll the time. And second, just like in a criminal case, when sentencing is entered, when a disposition is reached, that's the judgment. That's the official end of things. And the fact that there's an admission in this case can't toll the time. And I would give your honors a hypothetical, which is somebody could admit to a VOP or they could be found in violation at a contested hearing. And if there's never a disposition entered, right, never a resentencing, this could be hanging over their head indefinitely for years. They could be called back into court for a resentencing after any length of time. So the people's position kind of creates this indefinite period of time in between an admission or a finding and a disposition on that finding.
There are so many things that happened between 2018 and 2021. So many chances, so many appearances. So many discussions with the court, so many evident delinquencies in his probationary period. But we'd have to look and see whether those things mattered.
And I submit to your honor that they just don't matter. If Mr. Curry wasn't doing well, and there's times in this where he's not doing well, he's struggling to maintain his sobriety, it was the court's authority. It was the people. The people could have requested at any time, but it's the court's responsibility to enter that declaration of delinquency. And it simply didn't happen in this case.
Here's where I'm concerned about this, Ms. Weiss, on your jurisdictional issue. If we find that the admission, call it a plea, you know what I mean, December of 18, does not toll it or cease the necessity of a declaration of delinquency. That's really your argument. It's a declaration of delinquency was never filed, therefore it was never told. But if we don't look at the admission in December of 18, then it seems to me that every time that happens, you take the violation, then the probation could run out in short order. That's your point. So in every case, when there is no declaration of delinquency, no matter what, does that force, then the second question, does that force the court then to act and say, you know what, I can't let it keep tolling because I didn't do a declaration of delinquency. Now you've made the admission. I don't have to do one. No one does. You've admitted to it, but I've got to put you in jail right now because otherwise I haven't cured the problem. So is that where we're going? That's the question.
I think that the problem that Your Honor, that this hypothetical has in it is unnecessary, because when you have an admission, that is more than a reasonable cause to find that the violation has taken place. That's an admission that the violation has taken place. So boom, there's your declaration of delinquency right there. If the court doesn't have to go through its own process of finding reasonable cause to find a violation. When that admission happens, the court can just file the declaration of delinquency because you've got the admission. And that's the step that takes
Still be
place.
necessary even though you had the admission.
I think that's correct. And I think that that's good policy as well, because otherwise, what you've got is an indefinite period of time. And that's problematic in this case because the drug treatment court contract has there's no way for him to be successful on it. They don't define what success is for Mr. Curry. So he's over 3 years in drug treatment court. And without the declaration of delinquency, what happens in this case is that it puts a time limit on how long he can founder in that court for. And I think that that's
you don't argue, I don't believe, that because there was no declaration, the plea or the admission was invalid. Because that's not an unreasonable argument based on 4-10-30. The court has to make a declaration within 72 hours of the request from probation. Here, there was never one. Admitting probation without a declaration seems like pleading guilty to a crime with no complaint, no criminal complaint or indictment.
I agree, Your Honor.
But
I do
that's
believe
not-
that under Article 410, the declaration of delinquency is a prerequisite to an admission or a finding of a VOP. I think typically that argument would need to be preserved, and I recognized it's not preserved in this case, but under our point raising ineffective assistance of counsel, you've got an attorney in this case letting his client admit to a VOP, sign a drug treatment contract that doesn't define what the terms of success are.
I don't think it's ineffective to allow the defendant to enter the plea because at the time, his client faced some exposure, but your point is a better one that at sentencing, he needed to object, the counsel needed to object, but you raise a lot of interesting issues and we'll take a look at all of those.
There's one last point I'd like to make on this, is that this court has addressed this exact instance in a probation in a juvenile delinquency setting. That's a matter of Michael S., which I cite in my brief. And in that case, the court wrote that on a violation of probation, the court's authority to enter a dispositional order, right, the sentencing, expired on the date on which the order of probation expired. So I think in the juvenile delinquency setting, this court's already resolved this case. And if this case comes out the same way as that, then there's no jurisdiction and the case needs to be reversed. If there's no further questions on that, I do want to address the remedy that I think is appropriate for this case. And that is that the violation of probation finding has to be reversed and the accusations dismissed. And I'd like to make an analogy to CPL 38030, which is the statute that requires timely sentencing. And when you fail to have timely sentencing, the court loses jurisdiction to sentence a defendant. And the remedy there where the court loses jurisdiction is that the indictment must be dismissed. Even if a defendant's already been found guilty after trial or has pleaded guilty, that's the remedy when the court loses jurisdiction to enter a disposition and to sentence somebody. So that's what I think the appropriate remedy in this case would be.
To vacate the admission, but not the underlying crime.
No, not the 2016
All that's
plea
at
of
stake
guilty.
here is a little PRS. Because he served his prison sentence.
And
PRS.
And also vacating the finding of a violation of probation, which is like in the setting of Drake and Hatzman from this court, dismissing the indictment, which would be getting rid of the violation of probation.
Thank you, Tom.
Thank you, Your Honors.
Good morning, Your Honors. Ryan Ash for the people. Initially, I want to note that I mistakenly cited Code Section 143.1 rather than 143.2 for the proposition that the court has jurisdiction to hear a violation of probation case. Other than that, I think the court's well aware of where the issues lie here. And
Do you have any authority that says where there's no declaration the period of probation is told upon an admission to a violation of probation. Is there any case law on that?
I don't know if there's a particular case law as direct as that, but I think the case law also doesn't spell out the opposite, that a declaration of delinquency is necessary to violate probation. And especially when we get to drug court, where the idea is that we have someone who can benefit from drug court and has to plead guilty in order to get there.
Well, what's the import of the 72-hour requirement of 41030, which requires the court to declare the delinquency to decide on it within 72 hours?
Right. I
What's
think
the meaning of that?
that's and maybe in cases where the defendant isn't going to plead guilty and isn't going to be sent to drug court. The importance is that you can't make these claims that don't result in an admission and hold someone on violation of probation. And that's like, if the case had stayed in Supreme Court and he never pled guilty to the violation of probation, then the declaration of delinquency would be acquired because he'd still be in the original court and there would be no plea, so there'd be no authority to hold him on it. Here, he pled guilty to violating. So there's the authority to hold him is his admission. And that's why I would sort of push back and say, well, there was an admission here. There was, when violating probation, when you plead guilty to that, essentially, I think he actually did on the record, like as is required, admit to the conduct that was violating his terms.
And got a benefit for doing so.
Exactly. And that's one thing that I want to emphasize here too, is Mr. Curry, like everybody loved him. Every time he showed up in court, the judges were cheering him on. And there's no dispute that he belonged in drug court and was actually deserved many chances at getting straight. And that's the benefit of drug court. And I don't think that trying to, especially because drug court was on his consent, and now coming back and saying he actually belonged in Supreme Court as part of the rationale, I don't think that was the right case for Mr. Curry at all. Mr. Curry belonged in drug court. He deserved a second chance and he got multiple chances.
You say there's a distinction between drug court and city court that predated the statute.
Judicial diversion court. Yeah, there was some confusion there. And admittedly, I didn't know anything about drug court before this case. And the distinction being that there was a statutory statewide judicial diversion court that was created in 2009, I believe. And those rules were that it was for someone whose crime, I believe, was as a result of their addiction to drugs. And therefore, this was a necessary part. And that had a couple mandatory steps to determine whether judicial diversion court was necessary.
So are there two different drug courts in Monroe County?
I think there might not be two different drug courts, but how you get to the different drug
Two
courts.
different paths to the same court?
I am not actually sure whether or not the judicial diversion court ends up being a city court. It might even stay in Supreme Court or go to county court.
Well, this was Judge Elliott. He was acting county at the time.
Yeah, right. So, the understanding is that he is a longtime Rochester drug treatment court judge. That's what he does.
Anything further?
No, Your Honor. Thank you.
Thank you. Case number 816, People versus Roland.
Good morning, Your Honors. Leah Farwell, may it please the court, Leah Farwell on behalf of.
Actually, let's make sure we have opposing counsel
Yes, Your Honor.
is here with us, and you may proceed. Thank you.
I'll take the opportunity to raise this a little. I did not get to do that. Good morning. May it please the court, Leah Farwell on behalf of appellant Nateonna Roland. The lower court erred here in finding that Ms. Roland's case did not fulfill the 3 DVSJA factors and abused its discretion in unnecessarily applying the self-defense standard to the second prong of DVSJA. Briefly on the appeal waiver, while it is Ms. Roland's position that the appeal waiver is on its face invalid, if this court finds no error, that should not preclude review.
Can we just spend a little time on the waiver? When you say it's on its face invalid, you're not talking about the oral colloquy.
No, Your Honor.
That's word for word from the model colloquy.
Word for word from the model colloquy, exactly.
So that's fine. And if it were just the oral waiver, then it's valid. you're referring, there was a 1-page, 9-paragraph written waiver.
Yes, Your Honor.
And
And-
there's a couple of statements in there that are not correct, I guess is what you're relying on, paragraphs 5 and 6.
Yes, Your Honor.
But paragraph 7, I think the DA would argue paragraph 7 corrects the inaccuracies in 5 and 6. 5 and 6 say this is it, you can't raise anything, you're done. 7 says, well, there are some issues that survive, including legality of sentence, legality, so forth, so on. So that's, can we look at it that way? Or do we just, if you find any misstatement in a written waiver, then the entire waiver, oral and written, is bad?
Any misstatement in a written waiver, in my view, renders the whole waiver invalid and unknowing.
Do you have
However,
any cases on that?
I'm sorry.
Is there any authority for that?
I believe I cited in the main brief and in the appeal waiver
Okay,
point.
we'll take a look.
Please, Your Honor.
Would you extend that to an oral waiver too? So that if a judge were to make a misstatement and then, the next page, it's corrected. The kind of thing that we see constantly.
I think if it's corrected, there's some leeway there. However, if the defendant does not knowingly waive, if there's no knowing waiver of their rights on appeal, if they believe that any right or any appeal is precluded, then that would not, I believe that would be invalid.
But why doesn't 7 correct 5 and 6 then? And when you look back at the written waiver, applying that same logic to the written waiver, which I agree with, by the way, but I don't understand why we wouldn't extend that to say, well, paragraph 7 makes up for paragraph 5 and 6. You're reading it all at once.
Because here, this was a prospective general waiver that does not explicitly name the 6012 considerations, only contemplating plea and sentencing considerations related to the manslaughter charge. The people argued that Ms. Roland had a firm understanding of the rights that she was forfeiting, but again, it was a general waiver to a specific hearing that had not even occurred yet. In the second department in People v. Lucky, specifically where there was a DVSJA argument, the defendant there did not argue that the sentencing court failed to properly apply the DVSJA factors. Therefore, his waiver precluded his right to appellate review. Here, Ms. Roland is making the argument that the judge erred in finding that she did not fulfill the DVSJA factors and abused its discretion in unnecessarily applying the self-defense standard to that second prong. It's a matter of legal error.
Was the written waiver signed in open court? I didn't.
I believe so. Generally, that's how it goes in hearing.
That's how it usually is. I think it's required, right?
Yes, Your Honor.
But did it happen here? Do we know? And was it referenced? A lot of times they'll say you signed a written waiver. Do you understand it? Did that happen here?
The only thing that's giving me pause is I know this was during COVID, so things got a little dicey there. I can absolutely submit a post-argument response with that, answering that specific.
Because usually if there's a valid, we've seen the situation as a bad oral waiver, a good written waiver, and we say as long as the written waiver can cure it under Thomas, but it has to be acknowledged in court and the court signed in court and the court has to ask a few questions, like, do you understand that, so forth and so on. Would it not work the same way in reverse? Here we got the reverse. According to you, it's a bad written waiver. If it's ignored, then by the court at the plea and during the waiver, can we ignore it? Because if we ignore it, then the waiver is good.
Your Honor, I just think it's a question of whether the waiver covered the DVSJA, the ultimate consideration.
Okay.
So I will turn to the DVSJA point unless there are any further questions. So I will not belabor the point on the first prong, the substantial abuse. The record is rife with significant and intensifying violence at Mr. Benjamin's hands. What I would like to talk about is the bidirectional violence here. So Dr. Cerulli testified about the mutual violence during the 6012 hearing, where the roles of the victim and the perpetrator often interplay. Brenda WW tells us that even where there is mutual violence in a relationship, that does not foreclose a determination that the accused was a victim of abuse. Additionally, the legislature's intent was very clear here. In a world where 93% of women accused of killing a domestic partner experience intimate partner violence, there is no such thing as a perfect victim. Ms. Roland is a real person who experienced abuse at every turn, and the cumulative effect of that abuse affected her reactions. There was ongoing weekly physical abuse and no record evidence that that abuse ever abated. So going to the second prong, Ms. Roland demonstrated that the abuse was a significant contributing factor to her behavior on the day of the offense. Again, I would turn to Dr. Cerulli's testimony and her expert report. She completed a danger assessment on Ms. Roland's relationship and identified risk factors, including that he had threatened to kill her in the past, he owned a gun, and that he had avoided being arrested for domestic violence in the past. This put her at the highest risk for lethality at the hands of her partner.
These hearings are always tough when the victim dies because he wasn't around to give his side of the story. But once we get to the third factor, whether, assuming you met the first two,
Yes, Your Honor.
Whether it's in the interest of justice to apply the statute and reduce the sentence, she killed a man who was unarmed, and she ended up with 10 years sentence. Arguably could have been charged with murder. So, but she was charged with a B felony, pleads 10-year cap. It seems on the surface like the facts and circumstances of their relationship were baked into that offer. She could have gotten 25 on manslaughter. She got 10 for killing a man who at that time posed no threat to her. So what would you say to somebody who says it looks like she got consideration for being a victim already?
Your Honor, I would take issue with the fact that he posed no threat to her. He had been known to carry a gun. When he approached her at, excuse me, at the back of the vehicle, she did not know that he wasn't carrying his gun, and she felt real fear. And when we talk about the look in an abuser's eyes, I think that that language says everything that we need to know here. However, your ultimate question of, did she receive 10 year consideration here where she received 10 years? The minimum is for a manslaughter charge is 5 years. So I would rely on that. And just very briefly, the court failed in exercising its discretion at the 60-12 hearing. The court applied what appeared to be the self-defense CJI to that second prong, finding that she was not confronted with deadly physical force, and therefore, the second prong failed. This implies a vital misunderstanding of the relief requested. Provocation, evidence of threats, whether they're attacked or possessed a weapon, that's all relevant at a jury trial where the defendant is claiming self-defense. Here, it's irrelevant. Ms. Roland never asserted self-defense, and the court's erroneous finding that she was not confronted with that force was an abuse of discretion. And unless the court has any further questions, I will rest on my papers. Thank you very much.
Thank you. Ms. Healy?
Good morning, Your Honors. May it please the court, Harmony Healy on behalf of the people. Just to briefly discuss the waiver of appeal issue first, I would argue that this was the oral colloquy mirrored the language of the CJI and that it was a sufficient waiver of appeal. The court did have her execute the written waiver in open court. That's on page 10 of the plea transcript. Would
you acknowledge there's some misstatements of law in the written waiver? A couple of them?
I would acknowledge that, yes. But I think that the oral colloquy that the court did with the defendant at the time was sufficient to cure it. I think that it has also been held in a couple of different cases. The one that defense counsel just cited, People v. Lucky, they got to the third prong and said that the valid waiver of appeal did preclude her from challenging the harsh and excessive prong of the statute. So I would say that in this case, especially when she did acknowledge the waiver of appeal, she did execute the waiver of appeal, and the language in, as you said, Judge, I think it's paragraph 7, does cure the deficiencies that followed later on, as well as the court's extensive colloquy with her following the CJI model colloquy.
Let's assume, for the sake of argument, that the waiver is valid. Let's assume it's a perfect waiver. One of the issues here is prosecutorial misconduct after the waiver was entered at sentencing during this hearing. Are you suggesting that a defendant who waives his or her right to appeal thereafter the prosecutor just engage in wanton misconduct and there's no remedy for the defendant on appeal? That misconduct occurs after the waiver. You're suggesting we say, defendant, you're out of luck on that. No, I'm not suggesting there is. I'm not suggesting the contention has merit, but she's alleging, point 2 of the brief is prosecutorial misconduct at sentencing. Is that encompassed by a valid waiver?
So I don't know that prosecutorial misconduct would necessarily be encompassed by a valid waiver of appeal. I guess I don't know the law on that, so you've kind of got me there.
Does that strike you as right? If defendant waives, the prosecutor and the judge can do whatever they want, violate the defendant's rights and just rely on that waiver and says, you know, can't review it. That strike you as making any type of sense whatsoever?
You are making sense, Your Honor. I'm not saying that you're not making sense. I understand what you're saying completely. I think that there are certain rights that survive the waiver, I guess is what I'm saying. And I think wanton misconduct on the part of the court or on the part of the on the part of the defendant.
How about the court at a hearing such as this, after the waiver applies the wrong legal standard? That's another contention on appeal. Court, I'm not talking about the merits of the ruling. I'm just saying the court just gets it wrong and applies the wrong legal standard after the waiver's entered. Does not a defendant who waives the right to appeal, pleads guilty, have the right to expect the court's going to thereafter follow the law? And if the court doesn't, the defendant shouldn't be precluded from raising that issue?
So I guess my argument there would be if they applied the wrong standard, then you're sort of going to the legality of the sentence. If the court erred in getting to the sentence that it got to by a legal error, then I think that you're challenging really the legality of it.
Which survives a valid waiver. You're suggesting that we should perhaps address the merits of the contention that the court applied the wrong standards.
Correct.
Okay.
But I also think that the Second Department in Lucky did say that the waiver of appeal did preclude the defendant from challenging the harsh and excessive under the third prong. And I understand that this is different here. But if they went to 6012 and they were talking about the harsh and excessive standard in the 6012, then they clearly had a hearing. And they determined that the waiver of appeal would bar the claim of harsh and excessive in that case. And also there was
sorry to focus on this issue, but I'm concerned about the waiver, not necessarily this case, but because we have all these waiver cases and they're fairly airtight these days. But would you agree that if the defendant here pled guilty and got sentenced, took the 10 years, and then the very next day files an application under the statute for relief under the Domestic Victims Survivors Act, has a hearing and loses, the waiver would not encompass the court's ruling at that hearing, right?
I think you have to apply the totality of the circumstances. And that's what the case law says, that you have to apply the totality of the circumstances. And in this particular case, they were talking about having a 6012 hearing. So this defendant immediately
I'm just saying this point, and maybe I'm wrong, but somebody pleads and gets sentenced and there's a valid waiver, and then thereafter brings an application, which is usually how it's done under the new statute for victims of domestic violence. If the application is brought after sentencing, the waiver doesn't encompass whatever happens at that hearing, right? The waiver encompasses everything in the case up to sentencing and the judgment. It doesn't cover future applications, right?
Yeah,
or wrong. I don't know.
I mean, I guess I would say that the Second Department is thinking otherwise, and I would ask that you follow their reasoning, but you're the judges and it's up to you. But that's my argument. My argument is, you know, that's what other departments have held. And I know that waivers have been a hot button issue in all of the departments. And there was recently a case in the Second Department that held that that you can waive a right to a DBSJA hearing and People v. Hudson. And so I think that these are things that all of the departments are trying to kind of sort through. But I guess if there was some kind of misconduct that was egregious following the waiver of appeal, especially here in this case where he gave her what she had already anticipated that she was going to get, I think that then there really isn't a point in waiving your right to appeal. And so that would be my contention. And if there aren't any other questions, I can move to the second point.
Sure.
Okay, so first off, I would just say that the people are not disputing that the defendant was a victim of substantial domestic violence. I think that that is certainly throughout the record. And I have a lot of sympathy for this girl who went through the childhood that she went through. I think that, and I'm not denying the cumulative effect of domestic violence. I think that that plays a role here. I don't think that the court did either. The court determined that she was a victim of domestic violence. However, they determined that she wasn't under the effects of the domestic violence at the time of the offense. And I think that that's relevant here for a couple of reasons. The third department in Angela VV kind of went through a very lengthy analysis of the statute and the substantial contributing factor in that case. And so I understand that defendant is talking, or defense counsel is talking about that the court improperly imposed the CJI of justification. In Angela VV, they talk about that can be one of the factors that you consider is whether or not the defendant at that point posed an imminent threat. And in this case, and I understand, Judge, of course, this is he said, she said, but there were also certain witnesses that were present at the time. And so I think that that's one of the things that you have to consider is the evidence that came in through eyewitnesses who weren't even necessarily aligned with defendant or the victim in this case. And what they are saying is that she was angry, she was running through the hall, she was aggressive, she was swearing, she was yelling at him, you have a text message on your phone that I don't like, and she was following him out, and that this was her ordinary thing where she would say, you're not going to leave, and we're going to finish this, and we're going to fight it out. And that's what multiple people said on multiple statements that were submitted into the evidence. And what they said was they watched the entire thing happen, and they tried to stop her from going, and she said, no, I'm going, I'm angry. And so I think that at the time of the offense, I think that I would say that given those statements and the fact that the victim was kind of backing away with his hands up, and the witnesses described the victim as pleading with her, and like I said, I don't think that they really have any skin in this game. They were eyewitnesses who just lived in the same complex, and one of them was the apartment manager and one was the maintenance supervisor. And that he was just trying to leave. He was trying to get in the car and he was trying to go. And she was at the back of the car saying, you can't leave, and still aggressively fighting with him and yelling. So, and that aligns with defendant's own statements that she made to the jail, the person who testified that had been an inmate with her, where she said, I was mad and I stabbed him. So I think that when you're talking about the significant contributing factor, that's one of the things that you have to consider, and that's what Angela VV holds, and I would just ask that you adopt that reasoning in this court as well.
Thank you.
And then just also, just very quickly, I think that the court also found that there was just bidirectional violence, and I think that certainly Dr. Cerulli has very extensive experience in education and in particularize with respect to this particular subject. But Dr. Cerulli didn't have all of the facts. Dr. Cerulli didn't have all the statements of the bystanders and the family. She had certain arrest reports, but she didn't have statements that came from the family and friends and some of the neighbors in the area. And they all said that it was usually defendant that was initiating the violence between the two of them, that she was aggressive, that she was often physical with him. And again, under Angela VV, that would be one of the things that you could consider in determining whether or not this was a significant contributing factor. And then just to jump to the unduly harsh, Your Honor, I just would say that I don't think that the sentence was unduly harsh. I think that she did receive consideration from the court because this topic, the domestic violence, was before Judge Bowler throughout the entirety of the case prior to even him agreeing to the sentencing cap. So she got a significant break. She could have been sentenced to 25 and she was not. So I would say just in light of all of this, that the sentence was not unduly harsh. And if I could just be for a minute on the prosecutorial misconduct.
Briefly, your time is almost up.
Sorry. I can rely on my brief for the prosecutorial misconduct, but as this was a bench proceeding, I would just say that he is presumed to have followed the law.
All right, thank you.
Yes.
We'll read the brief on that point very carefully, we assure you.
Okay, thank you.
Thank you very much. Case 818 is People versus Scullin. I'm sorry, case 817, we'll do first. 817, Tunstall versus Department of Motor Vehicles, 817.
Morning, Justices. Alan Hoffman appearing on for the appellate. The briefs have been submitted and I've said almost everything I wanted to in the brief, but there's one item I'd like to point out that I didn't highlight from the refusal hearing. That is on page 40. At that point, the hearing officer, the ALJ, told the testifying officer, and this is at line 8, Officer Bayless, all right, you have the right to remain silent. Now, Officer Bayless in this case came to a refusal hearing without any notes, without any papers, and she didn't read or look at the videos that we submitted. There's a rule, you got to submit it 10 days before the hearing. This hearing was held about 5 months after the time that he was stopped, and he's still, of course, without a license. At the hearing, it's clear, and everyone both at the hearing and in the 139, AA 139, that's the ALJ's decision, and on the appeal, that the warning given at the scene of the arrest was deficient and not sufficient to result in a revocation of the driver's license.
Well, can I ask you this?
Okay.
The statute on the warnings, 1192C, I'm sorry, 1194C, it talks about the hearings and it says with the issues, the hearing should be limited to the following issues. Number 1, was there reasonable grounds to believe the person was intoxicated? You're not disputing that.
No,
Right. No, that was clear. Number 2, did the police officer make a lawful arrest? You're not disputing that.
no,
Right. You're disputing number 3. Was such person given sufficient warning in clear language prior to such refusal to take the chemical test, that such refusal to submit to such chemical test or any portion thereof would result in the immediate suspension and subsequent revocation of the person's driver's privileges, whether or not the person is found guilty or not. That's what the statute says the warning has to be. That warning was given, right? There was, the officer gave what you say is the first half of the warning, which included that language. The second half of the language isn't required to suspend someone's license, as I understand it, under paragraph F of the same statute. Evidence at a refusal hearing of a refusal shall not be admissible in any criminal trial unless the warning says, makes that advisement that
Correct.
if you refuse, it'll be used against you in court.
I agree. And that,
Yeah. So just so I make so I'm clear here on the record, the first warning was given. We saw it on the body cam video. You saw it.
yes,
Right. The second one is the problem that you have. That
Yes.
he wasn't advised that it could be used against him in a criminal proceeding.
or
Right.
any trial, hearing, or trial or hearing, which could even include the refusal hearing, by the way.
But so under the statute, all 4 elements, the issues that were for the ALJ on the warning issue, that particular warning was given.
Yes, and that's the only thing that anyone ever decided.
Right. So if
Okay, now-
if your client went to trial, then the second warning,
It's not going to come in. Yeah,
yeah.
it won't come in at the trial. I
But
don't.
where does it say at a refusal hearing, you can't suspend someone's license unless you tell them it can't be used, the refusal can't be used in another proceeding,
That-
another case?
That was the main point that I tried to get across in the brief and that I've argued. And that is the Commissioner of Motor Vehicles is empowered to make rules, regulations, forms, including the AA 134 to enforce the DWI laws. That's 1194E, subdivision E. And that's in my brief, and that's what you just said bothered me a great deal. I said, where does that second warning come in? How come that's in the required administrative warning for an administrative hearing? And that's based upon the AA 134 that says, and may I read it?
Sure,
Just
please.
okay. Refusal, after being arrested, the operator was warned as follows. Refusal to submit to a chemical test or any portion thereof will result in the immediate suspension or subsequent revocation of your license or operating privilege, whether or not you're found guilty of the charge for which you're arrested. Not a problem. Second one, your refusal to submit to a chemical test or any portion thereof can be introduced into evidence against you at any trial, proceeding, or hearing resulting from this arrest. Now,
Not given at the first warnings.
excuse me, I'm sitting understand.
Not given the first time the warnings were given. There's an issue, sharply disputed factual issue, whether she gave both warnings later at the station, right?
Yes, it's completely lacking of any proof.
Right, so there's two times she gave warnings. The earlier one, which we know she gave the first warning, not the second one.
The first warning was found deficient. That's the law of this case.
I'm talking about the first warning in the statute, the one that advised.
I'm talking about the warning that the commissioner has promulgated and requires.
Right.
That's what I'm talking
Yeah,
about.
I think what the problem is, that form you have there, the commissioner says there's two warnings in there. Only one is required by the legislature to suspend somebody's license. Do you agree with that under the law? We're just looking at V&T law. You only got to give the first warning. To
That's
suspend
what
somebody's license.
that's what it says, except for F, of course. Yeah.
Yeah, but F doesn't mean you can't suspend if you don't say that. It means you can't admit it at a criminal.
When you violate a commissioner's direction as to what should be given, because that second sentence pre-existed anything. That was when in People versus Thomas, when they said you could use refusals against people, he was given that warning. Everyone was given that warning. You go back far enough, like I ended up with that case in 54. All the officer had to do was call the commissioner of motor vehicles and say, "Hey, I got him driving while drunk, and they took your license." But has developed a great deal since then. And the commissioner, in order to enforce, and I think this is important not only for this case but other cases, to enforce these laws, he said you should give both warnings, because if you don't give the second one, the trial's going to go down the tube as far as that horrible jury instruction that's been given to it means that he's trying to hide something and to use it against him. And this is an administrative hearing. I've never seen one where the person who has the information, firsthand information, not the accomplice. Those are cases that were cited by my opponent, where the accomplice, the accusing person, in this case it's an officer, doesn't even have to appear at the trial. Okay, and that if you don't testify, there's a negative inference against you.
Well, let's assume that you're right, that both of the warnings were required to suspend a license.
Yes.
Even though the statute only says one.
Yes.
Let's assume that we agree with you, you got to give both. Otherwise, the defendant's license can't be suspended.
Right.
The case, then we get to the factual issue of, at the police station, Officer Bayless testified under oath. I know you claim she's lying or mistaken, but she testified under oath. I gave them both that time. There's no notes of that, as you point out. There is no body cam video of that. The hearing officer believed her.
Yeah.
You're saying that that's incredible as a matter of law, and we should substitute our credibility determinations for that of the ALJ?
Not exactly. It goes to the preponderance of the evidence standard and substantial evidence. I tried to keep this matter in front of special term because I read Harris v. Levine, which was decided prior to the 1990 amendment, which allowed Supreme Court special term to dispose of cases because the Fourth Department was getting burdened. Every time a Supreme Court judge had a petition, they said, go to the Appellate Division. I can't do it. I can't do it. Substantial evidence is something that's going to be decided by the judge down below. If he finds it, fine, but we have to plead it. You cannot let it go. And in this particular case, the thing we didn't talk about, and I know you must know this, that when we went to the hearing, we had this refusal warning, which says defendant refused to do the field sobriety test, attempts to administer a PBT. That's a portable.
But she was wrong on that.
Yeah.
Clearly legally wrong.
But she was
This
mixed
was not
up.
her best hearing.
She had a bad day. She had a bad day.
Bad day.
She had a bad day. So when we went, we had, which is rather unusual, and I think it must be done in all cases now, there's these body cameras. I didn't go to this hearing until I had the body camera footage after speaking to my client, a disabled American veteran. He said, no, nothing happened like that at the station. And when I saw the way I looked at the video, the first one, I said, She didn't read the required warning, required by the Commissioner of Motor Vehicles. I understand what you're saying about the statute, and that bothered me a great deal. That is the argument against me. But for the enforcement of the laws here, and to make sure people are convicted appropriately if they refuse appropriately after being given the warnings, I think this should set an example. An officer was completely unprepared. She didn't even look at the video. So I had the video of both the deficient warning while he was in the police car. And prior to that, she told him your license could be suspended or revoked because you failed to take the PBT, the field test, which was wrong. So already at that point, he said, I'm done. I guess I'm fried. I'm not taking any tests because he's got post-traumatic syndrome. But they got into that at the hearing, many, many pages of it, trying to talk about his being a veteran, what his problems are and all that, which really I objected to it, but that's what they got into. But at the hearing, so I have the report of refusal, which is somewhat confusing. And it doesn't mention anything about the time of the hearing. It doesn't fill in any of the information that the commissioner has determined should be given if they're going to use a refusal. So I had that and so I go to the hearing and I don't know what's going to happen, but you go to the hearing and my opponent called this a quintessential refusal hearing. It wasn't. The card or the writing that she says she read was not introduced in evidence and not read in evidence. That's always done. They do that. And then if they're not even there, they can use that according to the.
No, we understand. You laid this all out very well in your brief.
Okay, but just so everyone understands. So I asked her, did you make the same, did you do the same, did you read from the same writing, whatever it was, at the police station that you did at the scene? And she said yes, and they're exactly the same. And she couldn't figure out, why I asked that, because it seemed like it was just hurting our case. But then later on, when the ALJ played, he could only play the sound. He couldn't get the video going. We couldn't see anything. This is a virtual hearing. We couldn't see anything. And you're right. When a judge can observe, but here when she says, I didn't know what the hell I was doing, I'm mixed up. I mean, the flavor of it should have come across without having seen her. So, I mean, there's that. If there wasn't for that, okay. And he couldn't see my client. And he wanted to help. He asked her the questions. He tried to rehabilitate her because she was in trouble. What she swore to, she verified, was false. And well,
it could be false and it could just be a mistake. It doesn't mean she was lying.
It's false though.
Right. Doesn't mean that it's perjury or anything.
No, but it could be perjury.
It could be. Yeah.
You apply for a firearm and you say, I'm not doing drugs. You know what I'm talking about.
Right.
You could be, convicted, but he felt bad. He wanted to help her. He's the one who brought it all up. He said, well, it says here, you gave him another warning at the, and that's why I quoted that matter of Smith's Appeals Board, where as a matter of jurisdiction, the defendant's attorney or the appellant's attorney said there's no jurisdiction because there's no AA 134 form. And there they held, right or wrong, they said that there's in the criminal complaint, in the DWI papers, where, and you've seen DWIs, they put, I got the breathalyzer going here, and they only did it for the one case. And she didn't write anything about the alleged second warning because she said there's not enough room on the papers.
So we understand one of your main points is that the ALJ exceeded the scope of a proper officer.
And that could be decided below.
Advocating for one side, and we'll take a look at that.
Yes, Your Honor.
All right, well, we appreciate you coming in.
Okay, could I just have one more second, Your Honor?
Sure. We had quite a few, but
how long have we been going?
You're getting close, okay?
Okay. Oh, yeah. Okay, rationality. That's what it seems. It's plausible that she may have given the warnings at the station, but it's not reasonable to believe it and to base your decision on that.
Counsel, who's got the burden to show us that the law was complied with?
I'm sorry, I can't even.
Who's got the burden here to show us that the law was complied with?
They do.
And is it your position that they didn't meet that burden here?
Yes, Your Honor. That's exactly right. That's why I thought we could have disposed of it in front of Judge Martocci. And if you look at the petition, very detailed petition, the Attorney General put an answer that said that we're contesting the stop, we're doing this, we're doing it complete, and I went through every case she decided, and I briefed each case in my reply. Because none of them made any sense. They weren't cases from the refusal hearings, and they weren't, which has that presumption negative, and you got to look at a case where the defendant or the motorist did testify, so that you don't have that negative presumption that he's not telling the truth. And why believe her any more than him? He didn't lie about anything. I mean,
No, I have one more question.
yes, please.
No, the fact that, it's 5 months or more has passed since this, has there been a actual hearing or anything on the DWI itself?
No, Your Honor, we're in Cheektowaga. You may not be familiar with, well, you are familiar, no?
Well, I know where Cheektowaga
Yeah.
is, but I'm not familiar with
We've
what happens there.
got non-lawyer judges there. And the last thing I was asking here is for this court's guidance for that Cheektowaga court. Because you get some strange things that happen out there. They're both.
Wait a minute, your client was arrested October of 2022, and we're now 2 years past, and the criminal case is still going?
Yes, Your Honor.
All right. All right. Well,
And he still doesn't have a license?
Oh, no. He's been without it ever since.
all right, thank you. We appreciate
All
all
right.
your time and effort today.
I appreciate your indulgence in the matter.
Thank you.
One minute, explain.
We'll give, it won't be 2 years, okay, like it did. Case 820, Verhoff versus Dean, 820.
818.
Oh, I'm sorry. Yes, excuse me. I am not on top of my numbers today. 818 is People versus Scullin. My apologies. 818. And that is virtual. We have Ms. Hollenbach for the appellant. Mr. Banizak, usually they're on the opposite sides of the virtual courtroom. Ms. Hollenbach, you may proceed.
Thank you, Your Honor. The people's position in this case is pretty straightforward, and that is that the trash rip that was conducted 9 days before the issuance of the warrant, as it was described in the written and oral supplement warrant application, was sufficient to provide probable cause for the search warrant, and as determined by the issuing judge, and that the county court erred in substituting its own discretionary review of that information as supplemented by hearing more information in court that really, in a suppression hearing, that really amplified what was said in the application. It didn't refute it in any way. But
Ms. Hallenbeck,
yes.
Good morning.
Good morning.
So many cases we see in this context come up, as I'm sure you know, on a defendant's appeal.
Correct.
And when it comes to a suppression hearing, we typically say we defer to the credibility determinations of the suppression court. We have lots of case law, you know what I'm talking about, that says long. So it's here. Don't we need to do the same thing? I mean, essentially looking at the court's decision, the court made some pretty direct credibility findings saying that, hey, the officers didn't preserve any evidence. They didn't take photographs of any of the evidence. And as a result, I'm disregarding, or I forget the language of the court. So that's really what we got to look at here, the court's credibility determinations. Do you agree?
No, not in this case. And I do agree that it's difficult sometimes to sort through it because we're doing it backwards from the way we usually do it in some ways. I think it was incumbent on county court, and there's case law to that effect cited in my brief, to give that discretion to the issuing judge, unless something comes out in the suppression hearing that shows that the officers were intentionally or mistakenly misleading when they provided information to the issuing judge. And that didn't happen here. The information that they testified to in the suppression hearing gave a little more detail. And the things that the county court judge relied upon to determine credibility are not required by the law. The trash rip, if there's sufficient showing of drug material, is sufficient standing alone without anything else, and I would submit there is some other corroborating information in the warrant, but that is enough alone if the issuing judge determines that it's enough. And when county court required that they keep the drug narco test or take pictures of the drugs, he was going above and beyond. Had the warrant been brought to him, he could say, in my discretion, I'm not going to sign this warrant unless I see more. But that wasn't the situation. He's acting almost as an appellate court in this situation. He needs to give discretion to the lower court unless there's some very strong basis in the law or new information not to.
Well, that might be true, Ms. Hollenbeck. I think maybe if the court hadn't conducted a hearing, but here the court conducted a hearing and specifically wanted one, at least one of the judges did, to hear the testimony of the officers. In any event, we've got to look at the credibility from my perspective, but we'll also look at your point about the presumption of validity of the language of the cases. I know that that's in your brief as well. You also cite one of the, a case that was cited to county court, Mother Cell, one of our cases. You cite the Humphrey, in which Justice Presiding Lindley and I were on that case. But if look at both of those cases, it looks to me like there in the suppression court during they found testimony or evidence that there was evidence that was retrieved and maintained of the drug testing and of the glassine envelopes, whatever was there. So there, those are a little different because there was more. And here the court was really stuck with the fact that there was nothing, right?
That's correct. That's correct. But I'm back to my, I don't want to repeat myself, but my original argument, I don't think it was their role to do that at that point in time. And based on that, that made the search of the residence and the vehicle, there was sufficient probable cause to underlay. And I also would point out that the court, the reviewing court, the county court did not treat the information from the named informant as reliable or having any indicia of reliability, completely ignored that. And I would submit that there's some indicia of reliability in that corroborates the trash rip. The named informant gave information 6 weeks prior. It would have been about 5 weeks prior to the trash rip, that he had been at the house, that he had observed a marijuana and mushroom grow, and that he had bought marijuana. He wasn't under oath, it was hearsay, but he was named, and he was under arrest for a drug offense in that county when he made that statement. All those things, maybe not standing alone, given probable cause, but would support the probable cause, would give additional credibility to the officer's testimony about finding the drugs.
Also, was it clear from his statement when he viewed that?
He wasn't, no, they
growing, but
in there when he saw it.
Right, do we know whether he just did it or whether it was 2 years earlier?
Wasn't in there, Your Honor. And but he did it. When you read it, it sounds like it's contemporaneous because he refers to he is growing, but there is no date provided as to when that happened. And then the issue came up. I would also point out that there was no suppression motion made in regard specifically to the vehicle, that it was overbroad. And it really isn't an issue unless the court finds that there was sufficient underlying probable cause for the house. That was not raised in county court. It only came up when the lower court judge opined that even had he found sufficient probable cause for the search of the residence, that he would have not found that there was sufficient information related to the vehicle. I would submit, as I did in my brief, I won't belabor it, it's laid out in the brief, that there was enough of a nexus between a vehicle used in drug sales or potential drug sales to the house, and it was only for the vehicle that was parked at the house at the time of the search. Unless there are other questions, I would rest on my brief.
Thank you. Mr. Benezek.
Thank you, Judge, and good morning, Your Honors. The lower court here suppressed the evidence on two independent bases. The first one was, as the court has discussed after this hearing, which I think was essentially a Franks or Alfinito hearing, and the court made credibility determinations that these allegations with respect to the trash strip simply were not truthful. And our position is that that finding is supported by the evidence, and warrants this court's deference. And the support in the record is not only that these officers did not preserve a single shred of evidence, whether it's this evidence of leaf clippings, the mail, or the narco pouch test that was used. There was no photographs taken of this alleged trash rip. And I think the trial court also took a look at the allegations that were in the search warrant itself, which were extremely bare bones, and then that the officer added facts when he was questioned by the city court. For the first time in front of city court, the officer said, oh, there was mail in the trash bag as well. And the multiple leaf clippings allegation from the search warrant turned into the entire bottom of the trash bag. Approximately 4 to 5 inches of it was covered in marijuana leaves. So I think all of those things really concerned the court about the veracity of the allegation, and the court was well within its discretion to find that the allegation was not truthful, and therefore the warrant as a whole was not supported by probable cause. The court also made an alternative finding, which was that even assuming that the trash rip gave police probable cause to search the house, there was no probable cause to search the car in particular. And the search warrant was problematic with the car in two respects, in that the warrant itself did not specify a car. It said any vehicles present at the premises at the time of the search. So Mr. Scullin's mother, father, other family member could have been there. Their car was subject to search. That's clearly overbroad, but we also discussed in our brief that there was no nexus with respect to this specific car proven. So there was no probable cause with regard to the car specifically. And we cite People v. Gordon in our brief, where the Court of Appeals held that probable cause to search a house does not translate to probable cause to search a car. Lastly, I would note that the people also make arguments about an exception to the warrant requirement applying under the circumstances of this case. That was not preserved, even though the trial court found that no exception applied. That ruling was not made in response to a protest by a party, so it's still unpreserved and unreviewable under this court's decision in People v. Nellens. And for all those reasons and those in our brief, I'd ask the court to affirm the lower court's order.
Thank you. Now we'll get to 820 Verhoff versus Paul Dean.
Thank you, Your Honors. Michael Steinberg for Mr. Verhoff. This is really a very simple case. This is a person who was working on a roof because the water was leaking through certain parts of the roof, and he fell because there were no safety devices. It's a straightforward labor law case. But the court below held that he was doing something else, that he was engaged in routine maintenance, that he was replacing a component of the roof that had worn out through ordinary wear and tear. This does not make any sense to me, I'm afraid.
Your point is routine maintenance is something that occurs on a somewhat regular basis. These types of boots on the roof that 20, 30, even 50 years is not routine maintenance. That's a total replacement.
It is, yes, it's repair, a total replacement. It's not a component of the roof either. And I think in some ways the court overthought this, was trying to pin down a definition of routine maintenance that in the end substituted for a common sense view of it.
Well, if we look at routine maintenance, we can go back to Esposito 21 years ago now. And that was a case where a person came every month. Yeah, we have workers that do that, to come every month and do cable work or whatever it is, work at heights on a regular basis. And those were the facts of Esposito, and that's where the court ultimately found routine maintenance. Right. If we extend it to replacing something, are we going to, and we consider, well, now that might be routine maintenance because the part wore out. Are we going to need to do a forensic analysis of every part that's ever removed now going forward? Do you understand my?
Yeah,
point?
I think it's a really messy position that this case opens up into. And because, I mean, you know, I was thinking overnight that, come to think of it, the labor law doesn't say anything at all about roofs. And yet a roof is not something that exists by itself. It has to be on top of something. So that, you know, it just talks about buildings and structures. You could not, it would not be a very distant extension of the logic here to say, well, the roof is a component of the building. And because it's a component of the building and it wore out through regular wear and tear, well, then that's routine maintenance.
Roof shingle is a component of the roof.
Exactly. I mean, if I have never found a case where a roof was being patched or say the shingles on a dormer were being replaced, the worker is injured due to a lack of safety devices, and the courts say, oh, it's routine maintenance. All those cases are treated as ordinary labor law cases. And I think one of the things that makes it sort of clear that this is not is the really unusual argument made by the defendant that throughout simply asserts without any support anywhere that the boots are components of the vent stacks. They're not components of the vent stacks. They don't do what a vent stack does. They don't contribute to what a vent stack does. They do what a roof does, which is to keep the rain and snow from coming in on you.
What do you make of the argument? I interpreted it being the argument of the defense that there were a number of these different smokestacks and all the boots there were 5 or 6 of them, right? They had to be replaced. Well, they were replaced. And the one that he fell on wasn't the one that was leaking. There was leaking into the bathroom, right? Water was leaking.
Right.
This, as I understand, one of their many arguments was that the stack that he was working on when he fell was one that wasn't leaking, therefore was not in need of repair and it's just maintenance. Is that how you understood his argument? And if so, how do you respond to that?
I believe that's his argument. And I think it runs afoul of 2 of the fundamental principles of labor law jurisprudence. The first is that the statute is to be interpreted as broadly as necessary to achieve its salutary objective. And then the other is the job has to be looked at as a whole. It was clear from the testimony here, and it was clear to Mr. Dean, that those boots that were not leaking now were going to leak at some point in the near future. And the argument that the labor law applies only for one that is actively leaking is not only contrary to the case law, it's contrary to common sense. I mean, if you're a business owner, you're not going to wait for it to leak each time when you know the leak is inevitable, just as when a roof needs to be replaced. You know, if you're lucky, you get the roof replaced before it leaks. That's still covered by the labor law. There are cases which are cited by the defendant that deal with unusual circumstances, some sort of damage that is out of the ordinary. But those are cases that look like routine maintenance. And the courts say, yeah, well, you know, ordinarily these things get done through routine maintenance, but this is something over and above that. The courts do not look at prototypical labor law situations like this and say, what was the cause of the deterioration that led to the need to re-roof, that led to the need to repaint, that led to the need to point masonry. All those are things that are required over long periods of time because things wear out, because things weather, because time gets to all of us and all things. And those have never excluded labor law liability.
You and Mr. Fulvio disagree on a lot of points. Am I right that you would agree on this, that the question of whether it's routine maintenance or repair is an issue of law that we have to decide up or down? Somebody wins and somebody loses here today. It doesn't go to a jury.
I think this is easily decidable as a question of law, and no other question was raised. Every other element of labor law liability is made out here, and they put all their eggs in this one basket. It's routine maintenance.
No sole proximate cause claim. anything like one of those.
No, there's no safety device, gravity-related injury, and so on. There is simply no interpretation of this as routine maintenance that would not torpedo labor law jurisprudence on a very large scale. This is a central case. And the fact that they've come up with some really strange arguments, like it has to be actively leaking for the statute to apply, and it's a component of the vent stack, and so on. It seems to me that they're just trying to get this out of that. Those arguments can be rejected as a matter of law. It's not in this case, the fact question isn't even close.
Thank you, Mr.
Good morning, Your Honors. May it please the court. David Fulvio here on behalf of the respondent, Paul Dean. I agree with appellant's counsel that the issue in this case is rather simple. The issue is whether or not the plaintiff is able to make out that he is entitled to labor law 240 protection. The statute specifically enumerates when that protection applies, and included in that statute, or excuse me, not included in the statute, is the issue of maintenance.
Counsel, let me just start this right off, ask you, what was plaintiff called to do? What was his charge? Why was he there?
Yes. Plaintiff and his colleague had observed that there was they had heard some leaking. They went up on the roof and discovered that there was a worn out boot which surrounded a vent pipe, and that was the cause of the leaking. They notified my client, the owner.
And he said, fix that.
And he said, and they suggested we should go in and replace those boots. And he blessed it and allowed them to do so. And the work occurred over a 2-day period.
Okay, so would that infer that they were there to do something other than ordinary maintenance, regular maintenance?
What they were doing was addressing components that were subject to normal wear and tear. We had submitted an expert affidavit following an inspection of our engineer, which confirmed that these boots do in fact wear and tear over the course of time, and that in his analysis of the boot, that's what happened here. Now, there was discussion before about the distinction between the boot that actually was leaking and the boots that were not, including the one that he was servicing at the time he fell. Because those other boots were not leaking, what he was doing was essentially preventative maintenance. He was getting out in front of the potential for these boots to subsequently further wear and tear.
Counselor, you used the word he blessed them earlier. He paid them, right?
Yes, he authorized them to go up there and do the job. Yeah.
Right, but it's not as though the worker said, gee, we're remodeling a bathroom and we can't stand this water falling on us as we're doing our work. We want to go up on our own and replace a boot over here. That's not what happened. He hired them to do this work and he told them to do it, right?
That's correct, Your Honor.
Okay, and he's going to pay them to do it. He agreed to pay them to do this roofing work, which took a couple of days. They were on day 2 of the job when he fell, right?
Yes, because of the number of boots that were up there and the preventative maintenance to be performed.
It seems to me what you're suggesting is that if a worker is hired to do a job and the owner says, gee, I saw there's a problem up here. I want you to fix that. But you know what? While you're up there, gee whiz, fix all of them because I don't want to have to do this again next year. You want the worker to stop and say, no, hold on. I'm only protected for the first one. I'm not protected under the labor law for the other ones because that qualifies as maintenance. You want the worker to say, no, I'm not going to do the later part of the job. I'm only going to do the first part of the job, knowing that the worker is not protected. Is that where we need to go?
Well, it is our position that the protection doesn't apply to any of the work. But if the court were to agree that the first boot did rise to the level of a repair rather than maintenance, then we would submit that you have to look at the work that he was actually doing at the time of the fall, which was preventative maintenance.
So sometimes the worker is going to be protected and sometimes not, depending on what they happen to be doing during the scope of the project.
Yeah. Again, it is our view that the whole scope of the project was addressing components that were subject to normal wear and tear. And that is what this court has consistently held is outside the scope of labor law 240. We have an expert. Yep.
Sorry, Counselor. That's where I want to take you on that is that the way I read your brief, and I know you have a bunch of arguments, but the essence is what I think you just said, is this is a component of the ventilation system.
Yes.
That's your main argument, as I understand it. So taking that, Mr. Steinberg then counters that and says, wait a second, this is really a component of the roof. Are you saying, for example, anytime there's a leaky shingle and it's replaced, that's normal routine maintenance, so it becomes a component of the roof. But then also, what about the cases that he cites? I think there's a case he cites called Kolvenik from the first department and Velasco from the first department that he cites in his reply brief. And those are what I call the leaky roof cases. And Mr. Steinberg says, wait a second, in leaky roof cases, they don't go down to component analysis. They treat it as covered work in terms of repair work to the roof. So what do you say in response to that? That is, yeah, you can say it's a component of the ventilation system, but if we think it's really a component of the roof, then we have trouble distinguishing the leaky roof cases. That's what I'm going at, is that how do we do that?
Yeah. Well, first and foremost, so with respect to whether it's a component of the roof or whether it's a component of the ventilation system, I think an appropriate analogy would be, well, first of all, with the ventilation system, you have an opening in the roof that's created by the fact that there's a vent that's coming through it. And in order to prevent that opening from causing a leak in the roof below, it has to be sealed. A similar example is a door that's connected to a wall. There's an opening in the wall for the door. If there's weather stripping on the door that's meant to keep the cold temperatures and elements out from inside the wall, I don't think the weather stripping would be viewed as part of the wall as opposed to part of the door. Any issue with the weather stripping would be viewed as maintenance.
What I'm really driving at is, must we agree with you that this is a component of the ventilation system in order for you to prevail on that argument? Or do you also prevail if we conclude that no, this boot was part of the roof because it was there to protect from leaking like the rest of the roof does? So if we go down the roof path, so to speak, do you lose on your component argument?
I don't believe so, Your Honor, because those roof cases do not address the issue as to the cause of the roof needing the shingles to be addressed in the first place. There's no demonstration that it's simply ordinary wear and tear, as is the case here, as opposed to a leaky roof for alternative reasons that may be acute or abnormal.
What would you say if the roof there's rotted wood on a beam, the rest of it's fine, rotted wood, and there's water coming down and the workers go up to replace that beam of wood? What would ensue there on a labor law, assuming the same facts here? The defendant gave no safety devices, there's no sole proxy, there's no comparative fault or anything like that.
Yeah, there you're getting into actual structural features of the house or the building. And the labor law does apply to the erection and demolition as well. So to the extent that any erection or demolition would occur in that process.
It would be a repair of the roof, would it not?
Yeah. Yeah, but there would have to be, addressing the structural component that is, or the structural lumber that you mentioned that was rotting, which would be quite a different undertaking than simply taking out a part and replacing it, as is the case with a boot in a ventilation shaft.
You attempted to distinguish a number of cases in your brief where there is a repair of a malfunctioning part. You cited Cullen, Wolf, Pieri, Blackman, Brown. You've got a whole bunch. This is pages 20, 21 of your brief. I took a look at each of those cases, and a couple of them, Cullen in particular, was our case from 2016. They never did an analysis. This is the one where there was a tower mounted amplifier, and they had to go out and replace it, take it down because it was broken or malfunctioning. They never did an analysis of that amplifier to say, did it just wear out? Was it at the end of its useful life? And it would seem to me that you're suggesting that they should have, because if it was, it's routine maintenance. Got to take down the amplifiers once they get old and worn. But there was no mention of that. And the court didn't seem to care in that case because they said it's a repair. What the court did say is they found it significant. The plaintiff never performed preventative maintenance on the towers. They didn't go up on a regular basis every quarter, every year, every month, every couple of years, whatever. They didn't do that. And the court found that to be significant to say it's not routine maintenance. And that seemed to be a parallel here because this is a one-off. This is the plaintiff is go fix this roof now, go take out these rubber boots now. So how do you distinguish Cullen?
Yeah. I would submit that if the argument wasn't raised in colon, then there were probably facts known to the parties that would suggested that it wasn't just a result of ordinary wear and tear. Here, I mean, appellant's own brief even mentions in the statement of facts that there was at least evidence that someone had gone up there and applied some tar to these boots to address any wear and tear that had happened prior to that point. So I don't think the record is completely absent. I don't think it's completely absent from the record that there was other maintenance with respect to these boots.
Anything further?
If the court has nothing further, neither do I.
Thank you.
Thank you.
Case 821 is Printup versus Beckwith. The appellant has submitted. We have Mr. Hendricks here.
Thank you, Your Honor. In light of my opponent submitting, I am certainly happy to rest on my briefs, but address any questions the panel might have. I would make just one additional point to my statement, though. It would be remiss if I didn't mention the fact that in neither the plaintiff's brief, appellant initial brief or reply brief, did they make any argument that Stephen Beckwith should continue to be a party to this action. So if the court should somehow agree with the opponent, which I don't think you should, please at a minimum, let's make sure that Mr. Beckwith's name is removed from the pleading.
Mr. Hendricks, as long as you're here.
Sure.
It seems to me your primary argument is that there's no duty here because anything that happened vis-a-vis negligence was related to the truck, the Buffalo News truck, and therefore your client had no duty to it. So it almost doesn't matter what the plaintiff claims. Whatever happened with the plaintiff, it was a result of the truck, right?
Yes.
Okay. Here's what's the only thing troubling me is that the plaintiff then counters that and says, wait a second. When I fell on uneven land because of the deep snow that your client negligently permitted to be there, such is the argument. So as I understand it, so if we get beyond the duty, and we assume that your client was negligent, because we can only get into the causation thing that the court got into, even though your argument was primarily duty, the court kind of got into causation. But if we get into that, do we look at whether, if we assume that there was negligence to analyze the causation issue, do we assume that the property was in fact uneven? And if so, for example, is that any different than the plaintiff when falling down, there was a spike protruding there that shouldn't be there, or there was an odd shaped hole that, he fractured his ankle on. So you get what I'm driving at is they're making this argument is that, yeah, maybe the truck was related to the causation of the fall, but it's the unevenness of the turf that creates his injury. So aren't you responsible in tort for compensating him for that injury theoretically?
And I appreciate you bringing that up, Your Honor. My response would be first and foremost that the plaintiff is the one who placed their truck in the location where it was parked.
That's comparative fault.
It certainly, but then beyond that, the plaintiff is then the one who trudges through the snow, makes his own boots snowy, climbs up onto the truck, and then slips off of the truck. Now, I mean, yes, if there was a spike pit on our property, this would be different because his injuries would be related to falling on a spike pit.
Right. Well, you make a lot of good points, but the statement that he made his own snow buoy, I mean, I think his explanation would be because your client didn't plow, I had no choice to get my snow on my boots. It's not like a voluntary choice. I'm going to get some snow and put them on my boots. He's just walking and the snow ends up on his boots. I think that's how he would characterize that.
But again, it wasn't like this is the spot for parking and we have failed to plow it and thus we are negligent. I think I've probably had to argue against that in front of this panel in the past. That's not what happened here. Well, not this exact panel, but you know what I mean. That's not what happened here. He came to this location and put his truck where he ultimately parked it. And then after parking it and coming around to get to that side door, sees all of this snow. And in lieu of moving his truck so he doesn't have to go through the snow, decides to go trudging through the snow. He effectively decided to go dancing through the spike pit that we're now worried about, Judge Curran. I don't think that my client can be responsible for him falling off of his truck And there's no argument that the truck isn't the cause of this accident. They're not even arguing that.
Would it be different, do you think, if he, instead of falling in the truck, he fell in the parking lot where you say he shouldn't even parked? He's walking there and he slips on ice there.
Well, that is, of course, a demonstrably different
Yeah,
situation.
I know, I'm just asking you hypotheticals.
Yes, and I'm sorry then, so should my client be responsible if the plaintiff had slipped and fallen on the ice?
And he slips on ice in that area where the exact same place he was walking, but he slipped right before he tried to get on his truck.
Your Honor, to speak candidly, I did not do this deposition. My colleague did, and he was flabbergasted when the plaintiff gave this testimony because all of a sudden we had a motion to bring that we then won on. If he had slipped on our property, we would not be here today, Your Honor, because it's, again, then the cause of the slip was our property.
Gotcha. All right. Well, thank you very much.
Thank you. You get a
Yes. 822 Kier versus Wilmont.
Good morning, Your Honor. May it please the court, I represent the petitioner Tony Kier, and Attorney Rosenbaum is not here due to religious observance, so I'm here in his place solely for this argument. This is a David versus Goliath type scenario. The esteemed Wilmonts are a very prominent family. You all know that. They have a cancer center named after them. We're thankful for all they do. They want to protect their property in Mendon, understand that, but at what means and at what cost to my client is that issue. Despite being known in Mendon and in the know and being good friends with the Hunter sisters, the neighbors, they didn't know about the tax foreclosure proceedings against the Hunter sisters. The Hunter sisters, importantly, never contested that they failed to pay their taxes. They allowed their redemption rights to lapse. They lost their property. Judge Ark issued a judgment of foreclosure, and Mr. Kier believes that he acquired the property fair and square. He's an innocent party. The Wilmots obviously were very upset. I get it. It disrupted their domain in Mendon. But rather than taking the correct procedural approach, they brought a separate action to try their luck with a different judge. I believe that is problematical, and Judge Martin was the judge who handled some matters, and the Wilmonts wanted to vacate the foreclosure judgment, claiming lack of notice of the proceedings. Ultimately, Judge Martin ruled that there hadn't been proper notice, even though there were opt-out provisions in the local county rules, and she vacated Judge Ark's judgment. The kicker here said the county agreed with my client's position that the Wilmont's rights had not been violated and that the new foreclosure sale lacked statutory authority. Well, now we have a new foreclosure sale, and the county's asking, well, how do we do this? Can you give us some instructions on how to do it? That was met with silence. The big mistake here in the original order that Judge Martin issued was that the tax lien extinguished everything, and that there was no lien and therefore no basis to bring the foreclosure proceedings. So the Wilmots then proposed to add the Hunter sisters, their neighbors, to restore their property rights. Even though they had, the redemption had lapsed, they knew about it, they didn't complain that they hadn't received notice of the proceedings. It may have been an unfortunate circumstance, but at the end of the day, the property lapsed. The second order is what's at issue here, is a radical departure from the first order. Essentially, again, accommodating the Wilmots by giving relief to a non-party, the Hunter sisters. They got to relinquish their property rights. And then there was a prepackaged redemption amount that the county would receive of $290,000. Again, the Hunter sisters missed their limitation period, and it's like a statute of limitations. Once it runs, you can't just revive it from the dead. And so the points they're making here, that Judge Martin went beyond jurisdiction and exercised authority and powers that she didn't have. In granting relief to the non-party Hunter sisters, overstepping Judge Ark's foreclosure judgment, ignoring the county's rules with respect to, the right of redemption and the expiration of such, acting like an appellate court by substantially modifying its first order. And I think that Article 78 remedies are appropriate here. They're far superior than any appeal, as we're involving the Hunter sisters now. They're non-parties to the action, and they have gotten substantial recovery here. There was a side deal in which the Wilmots offered to pay $750,000 if they got their property rights restored. That wasn't something that was necessarily disclosed. Again, I understand why the Wilmots want to protect their domain. I get it. But I think it's at the cost of my client, Tony Kier.
Go ahead. Just applying this scenario to other cases in case this comes up again, where a municipality does a tax foreclosure sale, tries to give notice to everybody who might have an interest, misses one. Misses somebody who might have an interest in the property, whether it's a lien holder, a bank, who knows, whatever, a neighbor. You're going to have a situation, a period of time where then the foreclosure sale is nullified, vacated, suspended, whatever, stopped at that point because we have this claim for improper notice. We still have a property. I haven't been to this property, but sometimes the property is an urban property that requires a great deal of regular maintenance. My question is, if the Hunter sisters should be locked out of this now because of the first foreclosure sale, because they lost their property in tax foreclosure sale, until it's resolved, until the property is ultimately transferred, until we have another foreclosure sale, in this case would have been a couple of years, who maintains it? Who maintains the property? Who's responsible for cutting the grass, keeping it secure, picking up garbage on the property? The types of things that you may see in more urban areas, but is something that I would be considered with. I think one argument could be, well, perhaps your client, the one who made the bid on the property, who hasn't yet been successful in obtaining title, that person has to maintain the property. I think your client would say, I think that's unfair. Why do I have to go pick up the garbage at this property? The Hunter sisters might say, well, if I have no chance now to get the property, why do I have to maintain it? And so you have this problem where the property is in limbo. And it would seem to me that the court's decision in 2023 says, no, Hunter sisters are still on the hook until they lose title. And so that was one thing that was remedied. How would you respond? Do you have another way to look at this?
I believe that you can look at it that Tony Kier, believes in the sanctity of Judge Ark's decision and takes care of the property and continues to pay the taxes. And I believe that, correct me if I'm wrong, because I haven't had as much extensive knowledge of the case, but I believe that Tony Kier did pay the property taxes and acted like the owner of the property.
So you would say that, you would say the bidder then is on the hook if there's a fire at the property, if there's damages caused for a failure to maintain it, that the bidder is on the hook, even though they don't get title yet. It just seems that's an avenue we'd be going down. We'd be putting an awful lot of responsibilities on these unsuccessful bidders.
Right, but I think the appropriate manner to have dealt with this was to have gone to to Judge Ark and to make the motion to vacate. It would have been done expeditiously as opposed to a separate plenary action, which could take years.
And then perhaps Judge Ark
obviously has done.
Right, okay.
Because Judge Ark, when he issued the judgment foreclosure, was not aware of these notice issues, these due process claims. It was just a random foreclosure. They didn't pay. He's signing papers. He had no idea about the Wilmont's right of first refusal. But it sounds like you're suggesting there's some judge shopping going on. The Wilmont's wanted to avoid Judge Ark and thought they'd have a more favorable result from Judge Martin, who then obliged them by giving them relief they never even asked for. That's what I'm getting from the tenor of your remarks.
Well, I don't know Judge Ark, and I can't, make that representation. However, it was another procedural way to address the situation. Rather than make the motion to vacate before Judge Ark and present those arguments where there is jurisdiction, they went out to and got another judge, Judge Martin, and who issued her rulings, which we are now complaining of.
I don't think they picked her. I think she.
Well, no, she was assigned.
Well,
yes.
So the 2021 judgment came up to us, and we affirmed that without a writing. Some of these issues were argued there, and there were a lot of difficult issues in that appeal. But the county got up where you're standing and said repeatedly, mistakes were made on the notice. The Wilmont should have been notified of the foreclosure, and they weren't. That was a mistake of a title company we hired, our fault. Their rights were violated, and that then led, that was a factor in that case. But we affirmed that one. The Court of Appeals denied leave. So that's settled. Now we're talking about the 2023 case, where you're really taking issue with how the ramifications of the prior ruling. Judge Martin says, well, yes, because the judgment of the sale is vacated, automatically by law, it reverts back to the status before the sale, meaning that the Hunter sisters can redeem. You take issue with that, right? Legally.
Right.
And cannot that issue be raised on an appeal, direct appeal that's coming from the 2023 order and judgment?
I believe that the Article 78, or I'm arguing that the Article 78 is more appropriate because we don't have jurisdiction over the Hunter sisters. They got a substantial relief here. They got the property back miraculously. And now our argument is now there's just no jurisdiction. The court hasn't taken the Hunter sisters formally into the action and I think that violates my client's rights.
You're worried about the limited scope of review in the 2023 direct appeal. We can't deal with with the Hunter sisters, whereas we can here. That's why you're bringing this one.
And that's one of the primary reasons why we believe this is a better venue.
But how was she wrong? How was Judge Martin wrong on that? Once there's a vacatur of the sale that she ordered, that we affirmed, the Wilmot's position is, and the Hunter sisters' position is, we're back to square one now. We can get a redo. How are they wrong in that, legally speaking?
Well, this is where the statute, the redemption statute, they had a right and it lapsed. And it's like a statute of limitations. You miss it, it's tough luck. I mean, it's something you learn from if you miss one. But here, there's no provision to permit a redo with respect to the redemption.
So in your view, the auction should have been just between Mr. Kier and the Wilmots. Highest
Well-
bidder under, I know that you disagree with the 2021 judgment. It should have been your clients, but given the result there, the auction should have just been, they just start bidding against each other. Whoever bids highest gets it. Is that your
Well-
understanding of what you think should have happened?
Well, that was the result, but then you have. I'm not. You have that result.
Well, they never did get to auction, right? The second time it never.
No,
Because they sold it to the hunters and they
because
redeemed.
the lien had been paid, so
Right.
there was no basis for the.
Right, but that shouldn't have happened in your view. There shouldn't have been any redemption and it should have gone to auction. I guess what I'm asking is, at the auction, it should have just been, should it have been anyone in the general public or just the Wilmots and the Kieriks?
Ideally, we wouldn't necessarily want to have it go to auction, have it go to my client, but at least have an auction where it was open to the public. But again, getting back to this miraculous right of, that you get the redemption period back. I haven't found any case law that's directly on point. They throw out equitable arguments, but a lot of them don't really have much bearing with the foreclosure process. And
You don't lose your property because you don't pay your taxes. You lose your property because there's a foreclosure when you fail to pay your taxes. Until there's a successful foreclosure, there's people all over the place that are behind on their taxes, but they still have their property rights. So until you have a valid foreclosure sale, that's it. And if you have an invalid foreclosure sale, you're still at square one, and the taxes are mounting, and you're going to have to pay more, and you may have to now pay the costs of the unsuccessful foreclosure sale, because that's something that the municipality endured. But what do we do? I mean, how do we put the property? That's why I asked you that question before. How do you put the property in limbo? And that's what I don't understand.
Okay, and I think there may be more temporary limbo by bringing it back to the original judge that issued the judgment of foreclosure.
Mr. Rosenhaus has briefed these extensively. I know you just got called in here. Do you wish to rest on his lengthy brief at this point?
Yes, Your Honor.
Thank you. Thank you. Mr. Clark is next, I believe.
Good morning, Your Honors. Adam Clark for Monroe County. I think the first point, as far as this being a petition instead of the appeal, which the appeal was also brought, I think there's no need for a petition here because all of the same issues can be addressed in the appeal.
Do we have a date yet on the perfection of that? Has it been perfected?
Yes.
And we have a date in February, I believe, sometime, whatever. But all right, that appeal's coming. And your point is, let's just deal with a lot of these issues then, not now.
Deal with them in the appeal, which the county's not actually participating in the appeal.
But the Hunter sisters, their point is that the Hunter sisters aren't parties to that, and they're the main people here. They got a lot of money. They did get a windfall as a result of this. They're much better off than they were before.
I don't think that there's anything that the Hunter sisters have that can't be resolved on the appeal. The court still could make a decision about what happens with the property that would be effective as the Hunter sisters. So it's not necessary to bring them in because the court's decision will affect what happens with the property.
On the merits, from the county's perspective, this issue of once the sale is vacated, foreclosure sale, what are your views with respect to the rights of the Hunter sisters? Where are they? Can they still redeem? Is it too late?
The county argued in its appeal that was decided 2 years ago that the Hunter sisters shouldn't have another shot and that they shouldn't get further notice and another opportunity to redeem, and the court denied that appeal. And so we took that to mean that issue was closed. And and then we didn't initially, we did try to do a sale that noticed the public and also noticed the Hunter sisters, but didn't give them a specific right to redeem. It just noticed them as an interested party.
So what you think should have happened here on the sale is what happens on every foreclosure auction. Anyone and everyone can bid on this, including the Hunter sisters.
I wouldn't necessarily say that's what we thought should happen. We were trying to comply with the order of the court. We found the order of the court to be somewhat confusing. We asked for guidance. The court declined guidance until parties brought motions, but we went ahead with trying to do what seemed reasonable in light of the order that we had gotten from the court and gotten from this court. When we got different guidance from the new order, then we did our best to comply with that.
And the county's been made whole.
The county has been made whole, and the county is still holding the money that was sent to Mr. Currick and that was returned to the county. And that money to that point, in this case, and we specifically had negotiated this before the initial appeal, what was going to happen with the property. Mr. Currick had the property. I believe he was renting it out to someone who was operating a farm on the property. So it was being maintained. Mr. Currick was paying the taxes. The funds that we attempted to return to Mr. Currick included repaying all of the taxes that he had paid.
Are there any lawsuits arising out of this, independent of this, against the county based on the defective notice that was conceded by the county previously in this court?
There haven't been. I would think that if that lawsuit was brought, it would be brought by the Wilmots and not by Mr. Currick, because they were the ones who were damaged by the mistake.
Thank you very much.
May it please the court, Todd Ballard, representing the Wilmont family. I think the first order of business is whether or not we should even have this Article 78 proceeding. Move to dismiss it. And I have to file a brief in November to deal with the same issues. There is no need to have two shots at the same apple. The other piece with respect to jurisdiction is it was brought as a declaratory judgment action. I don't know of any law that he cited, any case law that says that a declaratory judgment action has to be brought before the foreclosure judge. Makes no sense. And the declaratory judgment action, and this action in particular, was to set aside the referee's deed. So under real property tax law, under the Monroe County Interim Tax Act, which is analogous, you can bring an action to set aside a referee's deed. Why would you set it aside? Because the foreclosure proceeding on which a referee's deed would have been granted was defective, jurisdictionally defective. The county conceded that. They conceded that it was going to be jurisdictionally effective. And I think what is really interesting here, this is the third lawyer, and the previous lawyer on appeal talked about redemption in terms of paying Mr. Carrick back his money. So what's happening here is the Wilmots are being disparaged, trying to do the right thing. There is money that went to the county, and there is money that was remitted to Mr. Carrick. He said no. He's talking about being an equitable owner. There's no such thing as an equitable owner. Either the county had the ability to convey the property or it didn't. I think what's interesting when you look at my brief, the Wilmot brief, we basically cite cases as a matter of law that Judge Martin was relying on that specifically said once a foreclosure sale is set aside and referee's deed is set aside, it reverts back. Now, there's been two briefs filed by Mr. Carrick, and those briefs did not at all address that legal conclusion and that legal statement as applied to the facts. So it'd be under point 2. page 14 specifically. It's clear, canceled referee's deed results in title return to the owner. It's very, very clear. So he may disparage the Wilmots, David versus Goliath, he may disparage Judge Martin, but that's not the case here. This Article 78 matter should be dismissed as a matter of law. We're going to be arguing the same issues again after we file our brief in November that are being addressed here today. Secondarily, I think that what's the most disappointing part here is that Mr. Carrick's counsel, the county, myself, and Mr. Johnson, Representative Hunters, we were trying to, by stipulation, address this precedent-setting case where no one really knew how it was supposed to play out. No one really knew how it was supposed to play out. But with respect to Mr. Firmadal concentrating on redemption, you don't have a redemption. And we represent a lot of municipalities, my firm does. That is only if there's a valid foreclosure. Here, there wasn't a valid foreclosure. So to talk about a redemption right, it's like two legal arguments passing in the night. Once it's set aside and the referee's vacated, and again, the Wilmots had every right to bring a declaratory judgment motion, and it was assigned to Judge Martin. To suggest that we were judge shopping is wrong. To suggest that we had some kind of conspiracy is absolutely wrong. This is the second time that I've been here arguing essentially the same issues. However, they're trying to collaterally attack, by way of this Article 78, a decision that in essence denied what we wanted and denied what he wanted. Right? I mean, what Mr. Carrick wanted. And Mr. Carrick, quite frankly, didn't want to have another foreclosure sale. He wanted to stay it. Why? Because it wasn't going to go his way. So I think that when you weigh the equities here, you look at the body of law, it's pretty simple. If something's a nullity, the parties are restored to the status quo, which means the Hunters have their property back. The Wilmots have a right of first refusal. And if anything, what was intimated to us during this 2.5-year odyssey here is that Mr. Carrick was going to sue the county for negligence, not the Wilmots, the county for negligence. They're the ones who hired the title company that missed it. And quite frankly, if the Wilmots had notice of their neighbor being in default for $36,000, they would have paid it. And we wouldn't be here with these judicial resources being wasted. Thank you.
Thank you. Mr. Johnson, good morning.
Good morning, Your Honor. Curtis Johnson, bond shop and King for the Hunter sisters, Jane Hunter and Mary Phillips. Judge Nowak and Judge Salina, you asked a really important question about the liability if the property is in limbo. Well, there's another question here. If there was another foreclosure sale and that foreclosure sale resulted in a surplus, who gets that surplus? Is it Mr. Carrick? Is it the Wilmots? Or is it the Hunters? It wouldn't make sense to give it to two of the parties that are actively bidding, especially if there's a two-party bidding system, because that would empower one party essentially to bid infinitely. You could bid any dollar amount because it's all coming back to you minus what's owed to the county. It doesn't set up a fair bid. The only party that could receive that surplus would be my clients. And that's because they own the property. As soon as that deed was stricken, if you did a title search, my clients would be the owners of the property. That deed was a nullity. It never happened.
And so this is suggesting that they got a windfall because they sold it for $750. If it went to auction and there was a bidding war between the Carricks, the Wilmots, and anyone else, and it got up to, as is probably likely, over $1 million, $2 million, whatever, your clients would have been the beneficiaries of that.
That's right. There's some suggestion.
It really wasn't a windfall that they sold it for $700.
No, I mean, they got a do-over on the county's mistake, but that's not a windfall. They own this property and they owned it for years and paid the taxes on it for years. They paid the school taxes on it, just not the town and county taxes. They made a mistake. I can't explain that other than my client told me she had cancer, but that's not a real excuse. They didn't pay it. But when the county makes a mistake and they're the beneficiary, I guess you could see that as a windfall, but it's also what's fair. It's also the only result that's possible, because the redemption period in the county code is tied to the sale. The redemption that exists in common law is tied to the sale. If the sale didn't happen, you get to redeem. You get to redeem the moment before the sale. You get to come to that sale and say, before the referee starts selling something, oh, I'm here to pay. And that sale is canceled. So the idea that it's some sort of statute of limitations, I've never seen anyone call a redemption a statute of limitations. I don't think there's any cases saying it's a statute of limitations. That it's waived when there's a redo is beyond the scope of the law. I just want to quickly address, there's a couple of ad hominem attacks in the papers, and they're kind of addressed at me. I didn't engage in any ex parte communications. To be clear, I called as soon as I got the county's letter saying that there's going to be a new foreclosure. I called Mr. Bullard to find out what was going on and if his client was in fact going to redeem as we had discussed.
Counsel, and you called him because they had a certain property right, didn't you?
I did, and I only spoke to the judge's secretary, and I said, hi, my name is Kurt Johnson. I represent the Hunter sisters, and I'd like to be on this call. That's not advocacy. That's not really an ex parte communication. And frankly, I'm somewhat offended by the suggestion that I engaged in ex parte communications. Beyond that, no one raised the problem with me being on that call during the call. No one said, hey, Mr. Johnson shouldn't be here. The Hunter sisters shouldn't be here. And in fact, the reason we're party to this lawsuit is because we probably should have been there. As soon as there was a right that involved my client, I should have been able to participate. And the judge was right to include.
Their argument that why shouldn't we just wait for the direct appeal is that your clients aren't involved in the direct appeal.
That's true, although I don't think the direct appeal, as I understand it, is going to result in something different. Here, what Judge Martin did was she was facing competing motions and she denied them both. She maintained the status quo. So she didn't grant any relief in that second motion. And the relief that was requested was frankly correctly denied. So I don't understand why in the direct appeal or here, they think they're entitled to any relief.
Thank you very much.
Thank you, Your Honor.
Case 823 is JHK Development LLC versus Town of Salina.
Morning, Your Honors. Rick Weber from Bond, Shattuck and King here on behalf of the petitioner. JHK Development, we're here on an original special proceeding subject to EDPL, section 207. Petitioner is seeking review and rejection of the determination and findings of respondent Town of Salina and its town board in relation to a use of its condemnation power. As noted in our brief in the record on this matter, respondent essentially rammed through a rushed condemnation proceeding that was built on a pretext. And this exercise is effectively designed to hand over a portion of my client's property to a private developer. One of the first things I think would be useful for everyone.
That's not uncommon in this context, correct?
It's not uncommon. Well,
it's
a bit of a loaded question, Judge Curran.
It was meant as such.
Yes.
But in any event, the loaded question is, don't courts, including ours, routinely find situations where the private developer ultimately is going to take the property, but we still find that there's a public purpose, particularly with respect to what's alleged here, which is along the lines of urban renewal. That's really the whole question here. You focused just now in your introductory statement on sort of a nefarious conduct. They rush through this and they have, there's nefarious emails with the developer. But really what our jurisdiction is pretty limited here. We have to first look at the public purpose. And doesn't this fit our precedent on public purpose sort of classically? That's a loaded question. You're right.
It is a loaded question, Your Honor. Thank you. I don't deny that the court in looking at this is to find a public purpose. But it can't be an incidental public purpose where it is a dominant private purpose. That is where the court must refuse to be a mere rubber stamp. And it must step up and it must deny this action. I mean, the respondent here is asserting essentially, hey, if I can give you any rational basis, Fourth Department, you gotta approve this. And that's not the case, Your Honor. The two kind of constraining factors that I think this court needs to keep in mind, this can't be an arbitrary and capricious determination by the town board. And I'm going to submit, and of course it's in our papers, a less than an hour hearing, less than 44 pages of record, hearing held on December 27th with a decision issued on the last business day of 2023, because the town supervisor wanted this to be rushed through ASAP, suggests that perhaps this is arbitrary and capricious. And perhaps the reason this town supervisor wanted this to happen was specifically to benefit a private party. Now, Judge Curran, if you look at this, and I think what's useful again is record page 357. This is our aerial photo. This is about what you've got of the site in the relation of my client's property to the Urban Villages site. Okay? In that scenario, it's very clear that the Urban Villages project already has 2 access points. The other thing that I think is notable, Judge Curran, if you look at the record, you will find that 2 months before this hearing, the town of Salina Town Board issued a negative declaration in a seeker process. And in doing that, they concluded that there were no significant traffic impacts with what this private developer wanted to do. Remember, they have 2 ingress and egress spots. In fact, for that matter, boy, I would have loved to have seen a record that had any discussion about all the other points on Buckley Road, where you could have alternate access if it was really needed. I would have loved to have seen, right, testimony of a fire department head or an EMS operator about the alleged concern of access.
I think it looks like, from my understanding of the maps, that perhaps they wanted an access at the other end of the property to make it more convenient for people accessing the soccer lacrosse facility. But your point is that if it's convenient is not enough to deprive a private property owner of their land when they had plenty of other places on Buckley Road to.
That's correct. That if we're to be held to the standard of convenience, that's de facto dominant private purpose. And again, this municipality had approved the uses of this property. It approved this developer, Urban Villages. We're not by any means asserting that this developer doesn't have a right to develop his property. Of course the developer does. And I think it's important to note also that the village is a bit disingenuous, or the town rather is a bit disingenuous in saying that the project is stalled, that the developer hasn't developed it, that it's vacant. This is a functional development that's already in operation.
We've seen some cases, and our court has probably been more lenient, in my experience, than any other court in the country, perhaps with allowing takings, right or wrong. Court Street Development was one. We've had a number of others. I've dissented in some of those, but we've seen cases where we've allowed the government to condemn property, take it from one private party and give it to another. Okay. I'm not sure that flies in federal court at the US Supreme Court, but we've allowed that before. Now here though, it looks like the town wants to take that road area to continue the road area, take your client's parking spaces, the southern border, but keep that that's going to be a public road, right? There's not just handing that over to the private developer. It's for the convenience of the private developer, but are they handing it over to the developer?
Well, Justice Lindley, that's an interesting point too. I would submit to you that no one is going to cross the property they propose to take from my client, except people that want to go to that private development. That's it. It's becoming a de facto third entryway point to that private developer. So I certainly understand what you're saying. And this court is replete with prior cases of road extensions and all of that. But I would submit to you that on the record you have in front of you, they haven't done what is necessary to substantiate this determination. It's obviously rushed. And I noted this in particular in the reply brief, Your Honor. The rationale of the pretext of bottlenecking, right? Bottlenecking magically appeared 2 months after their seeker review had said, existing traffic is fine. Bottlenecking magically appeared. They didn't present any experts at the hearing. They didn't present fire chief. They didn't present an engineer. They presented nobody to talk about bottlenecking. Where I argued on the reply brief that this collapses on itself is when you really dig into what counsel is now arguing in an attempt to salvage the town's, frankly, anorexic record here. They're arguing, no. It's not a concern about bottlenecking, somewhere on a public road. It's concern about bottlenecking on site. So let's be clear. The developer who has received multiple approvals to develop this site now all of a sudden has decided, well, geez, maybe I can persuade a municipality to take an adjacent property. What would be a good route? How about bottlenecking on my site? There's nothing in the record to show bottlenecking has occurred. In fact, again, record 357. This is an old photo. This is a photo from 2018. But this is what you've got on your record. There's no bottlenecking depicted here. There's no study that supports a concern about bottlenecking. There's no expertise that supports a concern about bottlenecking. One other quick point I think I want to note here, that it's rare that I come in front of this court and I have to tell the court, listen, the town is trying to tell you to supplement the record. This court should take that as a sign that the town's attorney recognizes how paltry the record is. We pointed out in our brief, they added 2 additional documents post-determination, and they're asking this court to take judicial notice of a drainage easement that they certainly didn't take notice of at their hearing. Hey, judges, you can go check the public records and find it for yourself. It underscores exactly how paltry the record was on this. So getting back to Justice Kerr's point, are there scenarios where a town can exercise its eminent domain power to take private property? Of course, we have a whole section of New York State Code on it, whole body of case law. And Justice Lindley, to your point, yes, this court has allowed takings.
We've allowed takings where the government takes property with no idea what they plan to do with it later. We've allowed that.
But you've done it on an established record. You've not been a rubber stamp for the whims of a rushed meeting by a municipality. You've demanded that the municipality at least go through its paces, at least provide some basis. Where's the reasoned explanation here? We pointed this out in our brief. There's supposed to be a reasoned explanation. I have no doubt, standing in front of the 5 of you, that you're not only hearing what I'm saying, you're listening. Now, maybe you won't agree with me at the end, but you'll listen to my points and it will be incorporated into your decision. On this record, there's no indication that this municipality did any of that. This municipality showed up 2 days after Christmas, had a hearing for less than an hour, 44 pages of record, then issued a decision on the last business day of 2023. That's a rushed process. There's no expert testimony. There's no video. It's almost comical. I hold this up. That's your evidence of traffic flow patterns on the property that is the Urban Villages property. Is it an outdated photo? Of course it is. But that's your record on the traffic situation on that property. So I respectfully submit they haven't met the requirements, even as Justice Lindley, you indicated, the fairly liberal requirements to substantiate the decision. And frankly, there's no harm to them for the court to hold them to that standard. If the court rejects their finding, frankly, they can do it again with a proper record, with proper submissions, with evidence, right? That we can properly address, and this court, if it comes back to this court, can properly consider. So 1 or 2 other things, just real quickly. I know my time is probably dwindling here. I would note that on the record at 150, there's a developer representative statement to ACETA. That was the Onondaga County Industrial Development Agency. This is from back in October of 2021. There's nothing about needing a 3rd access point. It's a very basic statement, but they're trying to explain the project. Nothing about requiring new access points and nothing about a bottlenecking concern on the property. The buildings that they had to start with were fixed as of that time. They've made changes, they've made edits. There's no explanation as to why they can't solve this problem internally on their own property. And then finally, on the record at 231, there was an EAF that was performed, right? Environmental assessment form that was filled out. That indicates that the access is going to be from Park Street. There's nothing about coming in from Greenfield Parkway. There's nothing about a need to come in from Greenfield Parkway, right? I think our briefs have been fairly thorough. If there aren't any other questions, I think I would rest on that.
Thank you, Councilman.
Hearing nothing further, thank you.
Good afternoon, Allison Cute with Hair Speech on behalf of the respondents.
As it's been discussed, this court has had numerous occasions in the past 2 years to consider what the standard is and actually provide significant guidance on what the standard is here for a condemning agency's public purpose. And we submit that the public purpose here has been satisfied because we are trying to provide a safe, yes, it might be also a convenient access point, but safety is one of the preliminary, primary concerns in the town board determining. By the way, it's the town board that determined that this additional access point should be secured. It was not at the request of the developer, unlike in other cases such as HBC Victor, where it was established that the developer had asked the town of Victor to intervene to try to acquire the vacant anchor space at the Eastview Mall. And in fact, on page 277 in the record, that is a part of the Onondaga County Planning Board's resolution from 2021, where it does reference the fact that there had been a 2020 traffic impact study relating to the Urban Villages project, and that ultimately there wasn't significant concern about traffic impacts. And of course, when you have a traffic study, you're looking at the flow of traffic leading up to the point of the private property. You're not, looking at the intra development traffic. And in that resolution, the board offered specifically the comment that it was encouraging cross connections to the adjacent office park to provide additional access to Buckley Road and to facilitate the use of nearby public transit services. That recommendation, and I think there was some ambivalence by the town, and okay, do we need this extra road? And I don't think the town should be faulted for not requiring it as part of the earlier phases, because it was always a possibility that the final phases of this project were not going to come to fruition. Fortunately, the two of the significant aspects of the project have moved forward, and the town board put its foot down on this final phase of the project that's going to include eateries, cafe, a brewery. It's going to necessarily increase the intra-development traffic at this development site. And it is a valid exercise of its police powers. This is the precise type of situation where a municipality should exercise its police powers to proactively address concerns about public safety. And sorry
for the interruption here, but just because I know you're mid-flow, but I mean, as our presiding justice today says, we've had a lot of these cases over the last 5 or 6 years. I know Justice Lindsay's been on a number of them. I've been on a number of them. And there's a limited scope of review with respect to the EDPL. And I think there was a case called HPC Victor that Justice Lindley was on, where we said that the court must determine whether the exercise of the power of eminent domain is rationally related to a conceivable public purpose. Here, the public purpose is urban renewal, and it's conceivable that you should provide additional access to it with respect to first responders and curing out whatever traffic problem. But the public purpose here is clearly to enable this project to succeed and assist with respect to urban renewal. You argue the police power. Not sure that's exactly where you wanted to go in terms of the overall public purpose, but you would say that the town here has articulated a conceivable public purpose for acquiring this particular property under these particular circumstances.
Yes, absolutely. And you're right, Justice Curran. The overall public purpose here is the urban redevelopment renewal, which enhances the positive economic impacts. But when you're looking at and specifically responding to the arguments that petitioner has made, that the actual need for an additional access point, really drilling down into what the need was and the rational basis supporting that need, is that it's for safety purposes. It's going to.
Because you would agree that the urban renewal purpose, we're going to create jobs. This factor was obsolete for a while, and we want to get some economic activity in there. Valid public purposes, valid public use. But those uses and purposes are going to exist regardless of whether this access road is taken or not, or built, correct?
Well, sorry.
I mean, they usually we see they take a land and then they create businesses on it or build on it. That's not this. That's going forward. This is just, oh, let's take some more land from somebody, or let's take land from somebody else so that we can have another way to get to this development project. So people, it's more convenient because there are other access points. So it's a little different than most of them that we see in that regard.
Well, in one respect, the fact that this property was entirely vacant before the urban villages took over and pursued this project. Now, as I said before, the fact that the first two phases have come to fruition, we still have this third phase that's a significant portion of this project and will ultimately complete that.
But the first two were not
enhancement.
to eminent domain, right?
Sorry, the first two phases did not encompass any eminent
The
domain.
only taking is of this little piece of land that is going to be converted into a public roadway leading to a access point.
And that access point will be leading to, if we don't get the access point, the town board is saying it does not want to move forward with that last phase because it feels that the access point is necessary to support.
And there's no other places on Buckley Road or anywhere else that they can access that?
Well, respectfully, the discretion of the condemning agency is pretty vast in determining what they require as necessary to
So your answer would be, it doesn't matter that they could do it somewhere else, as they have discretion, they can do it.
That is the established case law does state that.
Council, real quick, just a factual thing. I know there's a contention that there's two other access points. Looking at the map, is that I don't live there, I don't know the area, but looking at the map, it looks to me the main entrance is like on the curve where Buckley turns into a different name road, as I see it. And the other second access just goes into where the apartments are going to be. That's sort of a limited access as I see it. Or am I wrong on that?
That is my understanding. And actually that brings up a fairly important point here, is that it is the odd configuration of this particular parcel and the desire to maintain and keep some of the structures that have some historical significance that limits what can really be done within the development to alleviate intra-development traffic.
Vis-a-vis the soccer complex, whatever it is that seems to be underway, whatever, there's really only one access point now.
Right, and that access
And that's the one
point,
where
yes.
if there's the bend in the road and Buckley and some other state kind of intersection, people have to make a left across the turning road and to get in there. So there was a concern mentioned by somebody at some point about the bottlenecks. So they're trying to cure that, as well as provide access for first responders to this area, which may need it.
That's correct. I mean, the site used to be used for manufacturing purposes, so it didn't require the access that you might in order to get to all points of the site. If I could just touch on the drainage easement, I believe that's a red herring here, because it is, regardless of whether the easement itself is in the record, nobody's disputing that the easement benefits the town. And it's under that easement that the existing drainage facilities are in place. And that's because this is a town road. We're extending a town road. It's not, so the town already has played a role in the management of drainage in this general area. And the fact, I mean, more importantly, drainage has been addressed significantly in the seeker resolution. They address the fact, they acknowledge there's going to be stormwater discharge. They identify where it's going to be directed. And they also talk and find that the future use of the parcel or the taken property as a town road should include the implementation of stormwater facilities to address existing.
On that point, as I understood your brief, you're arguing we're just putting the road over the drainage, and we're not, I think the language of the cases is materially interfering with the underlying use. It's going to continue where it is.
Exactly. And it might need to be modified. It might need to be supplemented, but ultimately, the town, the engineering aspect of that project will have to address that.
If there's water discharge onto the petitioner's property, which he fears, there's legal redress for that.
Absolutely, Justice. And I just finally, I would like to point out that There is no argument in play here that the town somehow failed to comply with the actual requirements of the EDPL when it comes to notice, contents of the record. There is no requirement that direct mailed notice need to be given to every neighboring property owner because the notice by publication is a general notice to the public at large.
Just one final question. With respect to the secret review, you have, you could see that the project's going to be reassessed at the end.
Yes, so the segmentation, is that your question?
Correct.
Yeah, so segmentation here, it is proper segmentation. There has already been multiple secret reviews relating to this project. This is one that just occurred, and then there will be secret review once the site plan is before the town board for that final phase. And so therefore, under these circumstances, the segmentation is no less protective of the environment.
Thank you, Counselor.
Thank you.
825 is O'Connor versus SNS Construction of Western New York. 825.
Thank you. I think it's good afternoon this time, Your Honors. This appeal, I'm actually going to go in reverse order from the brief, in large part because of the way that plaintiff's brief framed what I think was a central issue of our appeal on page 30 and 31 of their brief. Namely, they start discussing the fact that it is appropriate, certainly, for a third-party plaintiff to move for defense and or indemnification against a third-party defendant at summary judgment in the underlying tort action.
Counsel, why isn't this academic? Because you already won a trial.
The reason it's not academic is because as it currently stands, there is an order from Supreme Court that says that a non-party insurer owes defense to the third-party plaintiff. They are not here, Your Honor.
So you've already won and they're not here. How is it getting back to Justice Noak's question? How is this not either moved academic or not properly before us? That's sort of, it's almost sounds like you're asking us to give an advisory opinion on something in this situation.
Then if that is indeed the court's position, unless
the other third-party defendant withdrew the appeal or didn't pursue it right after the verdict came in. That's in somebody's brief, I think, mention of this.
Yes, there was a Wallcraft had filed a notice of appeal but did not perfect.
So you got all the relief at trial that you wanted on this motion, your client did.
Well,
the third-party complaint is gone, right?
Yes, but there is the final question, though, is if the defense costs should be levied against my client ultimately.
Against your client's insurance, right?
Well,
or is it against your client?
Well, again, that's why the underlying order is so confusing, because it was not granted against my client. It was granted against my client's insurance company, which I've never seen before.
Not before us, because no one made a motion to vacate that order.
True.
I see the predicament you're in, Mr. Hendricks. I'm not criticizing for being here. I see you're doing the best you can for your client, but I don't know that insurer is here, and I'm not sure that your client is aggrieved on behalf of that insurer.
I would agree with you that the insurer is not here today. I do not represent the insurer.
But the insurer still has a remedy. Can still seek to vacate or can bring its own action, right?
Absolutely, and that's even assuming that the underlying order would be enforceable when they weren't a party to that action.
Well, we can't dismiss a complaint twice, right? It's already been dismissed. You want us to dismiss it twice? There's procedural problems with that.
Well, my only pushback to that, Your Honor, would be that it is entirely possible that the date that the complaint is dismissed is relevant.
Is there an appeal? I know that there was a judgment filed, but then it was kind of rejected. Are you worried about there may be an appeal from the verdict, from a judgment arising from the jury verdict?
As an appellate attorney, I'm always worried about a potential appeal, Your Honor.
So
Yes.
the 30 days hasn't started to run yet, right? Because the judgment hasn't been formally entered.
I cannot speak to that specifically, Your Honor, because at this point, that is still with trial counsel. Once it would be perfected, it would certainly come my way. So I don't want to answer that because I do not know.
That's another complication. That'll come before us if it does, on a could be very different record. Some
It
issues
will be
may
a demonstrably
come up,
different
so
record, Your Honor.
All of a sudden, we'd be opining on something that may not be pertinent to the decision in that case. I know what you're trying to do. You're trying to protect your client's rights, but I'm not sure that there's any harm or aggrievement here in any way.
But you didn't know that when you filed the brief.
I absolutely did not know that when I filed this
So
brief.
you
and when I
feel a little
perfected
bit
this
better.
appeal.
Your clients feel a little bit better now than they did when you filed the brief because they got the jury verdict, but we'll take a good long look at it. It's an unusual situation, and I know we got the insurance carrier there, and we will spend a lot of time looking into that, whether this is moot now.
Thank you, Your Honor. I appreciate the time.
May it please the court, Adam Amiro with Kahana Feld for respondent. To get right to the point of whether or not this is moot or not, the judgment hasn't been entered yet, so our appellate rights haven't expired. And and in terms of whether or not that trial addressed the issue of whether Fry was negligent, excuse me, at trial, they weren't permitted to introduce any evidence of plaintiff's negligence, if any, which would have been imputable to Fry. So that would be where the appeal would lie and why this isn't moot. And
Why hasn't the judgment been, it looked like there was an attempt to file a judgment based on NICEF, not that we look at that or anything, but what's the delay? The verdict was a while ago.
Yes, it was. The other two parties had submitted proposed orders that were rejected. I'm not aware of why they haven't been resubmitted or anything like that. But our 30-day clock has not begun to run yet. So there is still the issue of whether, although a jury trial has allocated fault, whether that allocation was correct.
So you want us to entertain this appeal?
Yeah, we believe it should be affirmed because the record available to the court at the time that it made the decision on summary judgment, it was clear that the incident arose from plaintiff's work in that he was on the construction site accessing his work area by taking the stairs. There's a question of whether or not he was contributory negligent because he had been up and down those stairs several times that day, and it was open and obvious that there was plastic covering the steps and no rail. And so that justifies the summary judgment on the contractual defense.
Can't things only get worse for your client if we entertain this appeal?
If there's,
I don't see how you benefit at all. It's been denied, so you went to trial, but you lost. So I don't know. We'll take a
Following
look
up
at
on
that.
that, if we grant any relief to the appellant on this appeal, you would prefer us to say it was dismissed or moot, right? I mean, because otherwise you got to do it again, theoretically.
well, yes, but also we would expect that the allocation of fault would be done again upon that appeal, which isn't part of this record, admittedly, because the summary judgment was prior to that.
We'll take a look at that. Thank you very much. Last case on the calendar, 8/26 and 8/27, Archangeli versus Global Industries Incorporated.
Good afternoon, Your Honors. John Collins on behalf of plaintiff Kathy Archangeli. Supreme Court erred in granting defendant Global Industries motion for summary judgment dismissing plaintiff's design defect and failure to warn claims. As to the design defect, Global failed to meet its prima facie burden. Whereas here, the defense allegation is that there's been a substantial modification of a product that relieves it of liability. The manufacturer bears the burden of proving that the product, in this case, the grain auger, was safe and free of design defects at the time it was sold. Under this court's 2015 decision in Chamberlain versus Mack Trailer, to meet that burden, Global had to submit an affidavit by an individual with qualifications, experience, and personal knowledge in the design, manufacture, or use of the product, demonstrating that it, A, complied with all applicable industry standards, and B, was reasonably safe for its intended use at the time of manufacture.
Just to move things along, your argument is that Mr. Hopper is just a sales manager. He's not an engineer. He's not an expert. And his affidavit is of no value on the issues of substantial modification.
Yes, not only is he, a former sales manager for one of Global's divisions, he did not assert in his affidavit that he had any qualifications to render an opinion as to the auger's compliance with industry standards.
Some of the exhibits to his affidavit show photographs and establishing there's alterations and there's differences. Your point would be that they have to be, just the fact that a product is changed doesn't mean it's substantially altered for our purposes. It has to make a safe product unsafe, and it has to relate to the actual injury. Like if there's a change somewhere over here on the auger, but the injury occurred for some totally unrelated reason, that's not enough.
That's true, and then even if a change relates to some component that is at issue, you still have to show that as manufactured, that component complied with all industry standards, and that the machine consistent with those standards was reasonably safe. In this case, that showing was not made, and because of that, threshold failure, standing alone, Global's motion to dismiss the design defect claim should be granted.
If they met their burden, then you rely on Thomas Berry's affidavit, which talks about how it could have been made safer for about $10, $13, and we understand that whole issue. Is there anything else you want to? Do you want to get to the failure to warn with respect to the other defendants, the Hares?
I do have a failure to warn claim with respect to both Global and the Hares. If you want me to jump to the Hares.
No, you can deal with it, whatever you want to talk about.
Okay, as to Global, we submitted expert proof that it was not simply a matter of a user knowing that a rotating component is dangerous, but that a user should be advised that, this particular point, this entanglement point, should be protected but was not. And the way that is done, our expert established, is by putting over the area that is supposed to be protected a decal or similar notification stating that shield missing, do not operate. This is hazardous. And if you can read that, then it means that you are aware that a shield is available, should be there, and was not. So it's not simply a matter of saying that, well, someone should have seen that this is a dangerous spot. It's critical that they are also told by the manufacturer that not only is it dangerous, but there is a shield available and it should be there, and you shouldn't use it if it's not there.
And Mr. Collins,
Go ahead.
The one question of fact that you point out in both as to the Global defendants and the other defendants, the so-called casual sellers, you say that the Hares testified that there was a shield there when they sold it, and the son testified, no, there wasn't. So you seem on the duty to warn, that leads into the point you just made. You think that question of fact needs to be resolved at trial between those competing events?
Right, because the Hares testified both that the shield was present when they bought it in used condition and when, as you said, Your Honor, when they sold it to J. Archangeli. A jury could believe half of what the Hares said, which is that a shield was present when they bought it used, and they could believe what Joseph Archangeli, the decedent's sons, testified to, which is that no shield was present at the time that they purchased it. And, you know, given that, even as a casual seller, the heirs are obligated to advise purchasers of known defects that are not obvious. And similar to the global argument that I made, you know, the hazard here is not that it is a hazard that there is a rotating component, but the critical factor that they should have been told is that, you know, yes, there's a rotating component, but there's a shield that was there and is no longer present, and you really should take care of that.
Mr. Collins, just a point of clarification for me, is do you agree that on the duty to warn as to all the defendants, that the defendants met their burden with respect to the open and obvious nature of the condition? I think that's their essential argument, the way I understand it. So are you saying that you raised a triable question of fact in opposition to the fact that they met their burden? Is that where you are on your argument?
Yeah, we raised a triable question of fact. Through that proof I mentioned, both that as to global, you know, as the manufacturer should have put a decal there indicating that a shield is supposed to be here. As to the heirs, they had an obligation to say, hey, when we got this, there was a shield there. It's no longer there when we're selling it to you. And as I said, you know, you should, you know, remedy that.
So
look into it, or at least be aware of it.
You're conceding that the defendants met their burden of proof, both sides, that it was open and obvious. What evidence specifically, there's more of a question for them, but you just conceded it. What evidence do you see that they established open and obvious danger as a matter of law? They have Hopper's affidavit. I don't see anything in there. They don't have any farmer affidavit who says, hey, this is, everybody knows this, that the entangle, I'm not talking about the auger part of the screw, I'm talking about where the gear, where the pipeline, the PTO drive line meets the gearbox. Where do they have anybody who says that's well known and obvious?
Well, they don't really have any to say that.
But you just said they met their initial burden. How'd they do it?
You know, basically my argument is that, I'll rephrase it, assuming they met their initial burden.
Okay.
And their argument was, hey, this thing is visible and it's spinning, anyone can see that it's a hazard. If the court agrees that, you know, that's sufficient, we have in any event raised the question of fact. If the court is of the opinion that they had to do something over and above that, then I would say that in any event, we did raise a question of fact.
Open and obvious to whom? Does the law say, to me looking at it, I've never been on a farm, it doesn't look that dangerous to me, that particular part. Other parts of the auger look very dangerous, but, or do we look at it, I think the law is you look at the plaintiff, somebody with his experience in farming and use of these. Do you agree with that? That it's subjective to that person, the user?
That's certainly one factor, yeah, is that, you know, there is case law saying that, you know, a user, you know, through historical knowledge and use, you know, you have to consider that in determining whether he or she should have been aware of the hazard. And again,
do they have any evidence of that?
All they had was evidence that he was a 59-year-old farmer and had used agricultural equipment, is the basis for their argument.
Okay.
And again, you know, assuming that the court finds that that, you know, is sufficient, we raised a question of fact. If it's not sufficient, then again, you know, for that reason alone, the motions, plural, should be denied.
Thank you.
Good afternoon. May it please the court, David Fulvio here on behalf of the respondent, Global Industries. There was discussion both you know, by counsel just now as well as in their brief as to whether Global Industries met its prima facie burden in moving for summary judgment. Appellant cites Chamberlain, but in our view, the more appropriate case to cite is this court's decision in Moore versus Deere and Co., in which this court found that the manufacturing defendant meets its prima facie burden by where it establishes that the plaintiff was injured as a result of an unguarded unguarded machine, and that at the time of sale or at the time it was placed into the stream of commerce by the manufacturer, that machine was in fact guarded. And that is what we have done here in this case. The
argument, as you know, is assuming it was guarded, it wasn't guarded properly. They needed, according to the plaintiff's expert, they needed a 360 degrees guard that guarded it so that no hair or clothing could get into that gearbox or that entanglement zone. And that's one of their claims. The other claims are that it was defective because the auger wouldn't shut down if it was removed, and it was also defectively designed because the guard was easily removable. Those aren't, you're just saying, well, we had a guard on there when we sold it, therefore we win, but that doesn't address their theories.
Yeah, I mean, addressing the theories raised in the Berry affidavit, first of all, there's no evidence, just to be clear, how the guards themselves came to be absent from the device. But going to the alleged defects in what is known to have been the design, Berry asserts the premise that the guards must last the life of the machine. In Hoover, the Court of Appeals specifically said that they don't necessarily agree with that. Berry also states that the guards must be integral. This court actually overturned a lower court decision in Beechler versus Kilbrose Co., in which that same premise was asserted. That was also raised in the Patino case, which is cited in our brief. And essentially, the reasoning asserted by the Second Department is that saying that it has to be integral runs afoul of Robinson, which says that a manufacturer need not incorporate safety features into its product to guarantee no harm will come, no matter how careless or even reckless the plaintiff may be. So what Berry is saying is that based upon his judgment 30 to 40 years later, the design could have been better. But it doesn't rule out that the design was actually sufficiently safe at the time it was released to the stream of commerce. And many of Berry's points have been rejected in other cases as well. And those cases are cited in our brief.
Thank you, counsel. I wish to address the other issues.
Yeah, regarding the issue of the failure to warn, the argument is that the decedent was an experienced user. He had used grain augers on his parents' farm since he was a teenager. And just about all of that, it was confirmed in the deposition testimony that just about all of that equipment had a PTO, as was the case here. Specifically with respect to this grain auger, he had used it over 100 times in the 6 years he owned it. And of course, there is the testimony that when it was purchased from the Hares, it did in fact contain those guards. So if those guards subsequently went missing, he would have been aware of the fact that they weren't there.
We have to assume there's issues of fact for this. We have to assume it wasn't there, the guard. But you're saying it's just so obvious to somebody experienced in farming and using these machines that you can't get anywhere near that gearbox. Because that PTO driveline isn't dangerous in and of itself. You can touch that all you want. It's just where it comes into connection with the gearbox. And you're saying that's just obvious to everybody, or just to somebody like him?
To somebody like him. It's just like in Swiklinski versus Sears Roebuck, in which this court found that a plaintiff who was injured using a table saw that it had used 30 times previously should have been fully aware of those dangers in it being exposed. And the same was true in Lamb versus Kaiser Industries Corp., also a decision of this court in which the plaintiff had substantial experience working with a bridge saw. But going back to the whether there's...
Can I just stop, because this is an important point for me at least.
Yeah.
What you say makes a lot of sense, that he should have known this was open and obvious, but do we need some evidence to that effect? Somebody with comparable farming experience, somebody who knew him, somebody, because we're not going to hear from him, right? He's no longer with us. but is there some evidentiary showing to show that needs to meet your burden to show that it's open and obvious, or can we just look at it and, I'm not a farmer, I have no idea, never seen a grain auger in my life, but I can just make a determination as a matter of law that that's open and obvious?
Yes, based upon the testimony supplied by the plaintiff, confirming the decedent's experience.
But the experience, but we have to tie his experience to knowledge.
Correct.
Okay.
And that appears to be what was done in Schwicklinski and Lamb. You mentioned that the potential issue of fact that exists between the statement by the Hares saying that when they sold it to decedent that the guards were in place. But there is no issue of fact as to whether when the Hares, when they purchased it at the auction 2 years earlier, that the guards were in place. So if we track the chain of events, it was manufactured with guards in place, and at the time the Hares acquired it, secondhand, third hand, whatever it may be, over approximately 30 years later, the guards were still in place.
Thank you very much.
If there's nothing further, thank you, Your Honors.
May it please the court, Ryan Mills for the defendant Hares. What we have here is a true casual seller, farmers that have sold one product over a period of 10 years, this grain auger. The record shows casual sellers. This particular condition was readily discernible, very obvious to anybody with any farming experience. Even without farming experience, you see this device spinning at a high rate of speed, but certainly this particular plaintiff that had been working for over 50 years in the farming industry had many other grain augers they've used before. They would know that it did not have a shield on it.
Your client's testimony, I believe, was when he dealt with the decedent talked to him as if he invented farming.
Yes.
Someone who invented farming, I mean, I know he's exaggerating, but this was not a novice.
Someone very experienced in farming would have used other augers. Presumably not every auger he would have operated would have been missing a shield, and been very familiar with the augers and whether or not they had shields.
All right, so in your view, it's open and obvious?
Yeah, true, the classic case, casual seller, open and obvious, readily discernible, just by its nature, that you have this high-speed spinning object there. And this was not the first grain auger he ever operated.
I understand. Thank you very much.
Thank you.